Welcome everybody to our session on the best practices for dealing with self-represented litigants. I'm very excited about this. I'm convinced that we're on the brink of a small revolution here, moving away, deliberately moving away from the adversarial paradigm that all of us that went to law school are addicted to, and taking on a different paradigm for making certain that self-represented litigants have justice provided to them. We're very, very pleased that we'll start this session with someone who probably doesn't need an introduction, but will you help join me in welcoming the Chief Justice of the State of Arizona, the Honorable Scott Bales.
Well, good morning, and thank you for that welcome. And Judge McMurray, thank you for inviting me to speak this morning. This is a topic that I think is vitally important, not only for our justice courts, but for all the courts in Arizona. For that reason, applaud the people who've organized the program, the people who worked on putting together the best practices, the faculty members. You have a great group of speakers over the course of the morning, and all of you for your interest and for your attention. The justice courts in Arizona are, for many people, the face of our judiciary. Last year, in the justice courts here just in Maricopa County, we terminated more than 346,000 cases. And in the majority of those cases, as you well know, at least one side was self-represented. So you are on the front lines of recognizing the challenges we face in our courts of meaningfully affording access to justice to a population that is very diverse, that as compared to most other states in our country has a large number of people who are impoverished, and a large number of people for whom English is not their primary language. And that makes all the greater the importance of our making sure that our courts are accessible to the communities that we serve. Another reason that is vitally important is the success of our judiciary, the maintenance of an independent judicial system, depends long-term on the confidence of the public. And public confidence depends, of course, on people thinking that they've been afforded justice when they're involved in court proceedings. It's important in order to assure compliance with our rulings. It's important to ensure long-term support for a justice system based on the rule of law. And that's why I said earlier that the topic that you're taking up, I think, is vitally important. You know, all of us who are regularly involved in the court system, we focus, understandably, on achieving fair outcomes. In fact, I think a lot of people who are in the courts, if they were asked, what's the most important thing that you can do in terms of your decision making, many people would probably say, well, I need to reach the outcome that is just, the outcome that is fair. And we think of that in terms of reaching a conclusion, whatever the ruling, that is consistent with the applicable law and the relevant facts, and is made irrespective of characteristics of the parties that might be irrelevant. Doesn't matter whether you might like or dislike a particular litigant before you, you make the decision that reflects the facts and the law. Interestingly, though, if you went to people outside the justice system, and this has been confirmed in study after study, they would say that the fairness of the process is as important as the fairness of the outcome. And in many circumstances, it might be more important. And that's true across a vast realm of human behavior. I mean, think about it. It's true in contexts that range from disciplining children to making decisions to terminate or promote employees. And it is vitally true in the context of court proceedings. So if you ignore everything else I say, I hope you will remember that fairness process is as important to what we do as the fairness of outcomes. And for the parties who appear before us, it often will be the most important aspect of their interaction with the court system. Now, There is some good news and some bad news about our courts around the country and about our courts here in Arizona. Last year, the National Center for State Courts released the results of a survey of 1,000 voters across the United States. It's a statistically validated survey, and in some respects, it was very encouraging because as compared to survey results from 2 years earlier, the respondents gave more favorable responses with respect to the fairness and impartiality of the courts, whether courts provide good customer service, whether we provide equal justice to all, whether judges and others in the court system are hardworking. So that's good news. Similarly, as compared with the 2012 survey, the results reflected more positive responses with respect to various procedural fairness attributes, things like whether people were treated with dignity and respect, whether the decisions were unbiased, whether the judicial officer had listened carefully to those appearing before them. Positive developments on every front. And if you look at things like the Court Tools surveys here in Maricopa County, we similarly get pretty good marks. But here's what troubles me about this study. If you look at those who've actually had interaction with the courts, the positive responses drop. Those who say that courts treat people with dignity and respect, it's a lower percentage for those who've actually been involved in court proceedings. Similarly, the percentage who say that the decisions are unbiased or that people were listened to by those before whom they appeared. So this is a reminder that we need to give attention to whether those who appear in our courts come away feeling like justice has been done, and not only to whether the outcome has been fair in a particular case. Now, the best practices that you're going to talk about today speak directly to that issue. And they reflect a lot of wisdom that's been acquired through studies over recent years about what really matters in terms of process fairness. And it can be broken down pretty simply. It's usually described in terms of 3 or 4 elements. I'm going to quote from an article by Joel Brockner that was actually in the Harvard Business Review. He categorizes the elements of process fairness in terms of 3 areas. The 3 drivers being, first in his mind, how much input people believe they have in the decision-making process. Are their opinions requested and given serious consideration? And it's easy to imagine as you listen to these how you could think about this, as I said, in realms that range from disciplining children to making a decision whether or not to promote a particular employee. But the application in the judicial context, I think, is all the more self-evident. The second driver that Brockner identifies is how decisions are perceived to be made. And here the perception is as important as the substance. Do people see decisions being made consistently? Are they based on accurate information? Can mistakes be corrected? Are the biases of a decision maker minimized? Is ample advance notice given? And is the decision process transparent? Third is how decision makers in fact behave. Do they explain why a decision was made? Do they treat people respectfully? Actively listening to their concerns and empathizing with their points of view. Now, if you're familiar with the work of Tom Taylor, a researcher, a social psychologist who studied why people comply with court decisions and what their perceptions are of how judicial decisions are made, you probably recognize that Tyler has a 4-category approach, but it substantively overlaps with this, because Tyler talks about whether people have voice, whether they have an opportunity for their views to be heard in the decision-making process, whether the process has neutrality. That's similar to the consistency and transparency that Brockner talks about, whether people are treated with respect, and whether the decision maker has earned trust. And that relates to whether people have the perception that their views have been considered in the decision-making process, and the person who's deciding cares about hearing those views and has taken them into account before making a choice. Now, as I said, the best practices reflect these basic principles and the concern to give attention to process fairness in our decision-making. That you are here today reflects that the leadership of the Justice Courts and Maricopa County Superior Court recognizes how important the best practices are to the work that you do. I'm delighted to be here, and in recognition of the importance of the adoption of the best practices in this program, I'm delighted that there's a nice coincidence, because I can announce that one of this year's Strategic Agenda Awards, something that we do every year to recognize efforts that have contributed significantly to the different elements of the court's 5-part strategic agenda. One of the awards for this year is being given to Judge Stephen McMurray, Judge Gerald Williams, and Charlie Adornetto, your Judicial Education Officer, in recognition of their work on the best practices in this program. It's the award that will go You know, this effort relates to several aspects of the strategic agenda. Promoting access to justice, improving court processes, enhancing professionalism, and the award has been given for enhancing professionalism. I should say, I don't decide who gets the award. There is an 8-person committee from the Arizona Judicial Council, 6 judges from all over the state, and a couple public members, and they look at various candidates, and they just, within the last week or so, decided who would receive the awards, and these will be given at the court's annual statewide leadership conference next fall. So I join others who've congratulated the recipients. So you're about to hear part of what is an award-winning program from outstanding presenters on a vitally important topic. So I hope you enjoy the session today, and I thank you for all of your work in helping to advance justice in Arizona.
And before the Chief Justice leaves, we're actually going to take a brief break from our program, and I'd like to bring Paul Julian up.
Once he's dressed.
Well, thank you very much. I didn't know about the award. That's just wonderful. This group, this is really a first, and so congratulations to the folks who are putting this together. As you all know, we have a 3-week program of new judge orientation because I think everybody in here has been through it. And at the end of our last week of the program in 2015, Judge Osterfeld was on duty, official military duty, and he was not there for the presentation of the final certificate. And Chief Justice Bales has offered to give that certificate to him today. So Judge Osterfeld, would you come on up?
Okay, she wants a picture, guys.
Thank you very much.
That's great.
Thank you.
Congratulations on that award.
Oh, thank you very much.
That's nice.
Thank you. Steve, did you want to introduce?
Thank you, Justice Bales. Our next speaker is my personal fearless leader, but also I've been very delighted to find out that I can think of her also as a co-conspirator in this project we've got of departing from the adversarial paradigm. She has been a pioneer in assisting self-represented litigants, especially in areas like dissolution of marriage, and other areas in Superior Court in which you've got to move past the traditional role of the judge in order to help citizens obtain justice in their programs. So would you join me now in welcoming the presiding judge of the Maricopa County Superior Court, the Honorable Janet Barton.
All right. Unlike Justice Bales, I'm going to speak from a seating position, and I'm going to use notes. So that's why I'm at the trial court level. So Justice Bales talked about how important it is to have procedural fairness in your system and how important it is to make sure that the litigants feel that they have been heard and have had access to justice. And so what I want to talk about for a few minutes is what we can do to make that happen, make that a reality in the courts. And the justice courts hear far more cases where one or more party is unrepresented than we do in the Superior Court. But I just wanted to put this up to show you that we do feel your pain. We have a lot of unrepresented litigants appear in our courts, primarily in the family court and probate areas. And you'll see the order of protection, the number of self-represented litigants is basically off the charts. That's part of our family court, so I consider that part of the family court. But I'd say between 80 and 85% of our family court cases involve at least one side that's unrepresented. So I think it's why family court can be one of the more challenging assignments for our judges. Because what do you do when they're unrepresented? What can you do? What should you do to make sure that they leave the courtroom with the results that are correct under the law and that they've had the opportunity to be heard and have been afforded access to justice? For years, we've all heard this quote that basically boils down to a self-represented litigant is entitled to no more consideration than if he had been represented by counsels, held to the same standard, supposed to know the same procedures, the same law, has the same notice of statutes and local rules as would be attributed to an attorney. And I can't imagine anyone sitting in this room has not heard an attorney give you this quote. I believe that it's required to be a family law attorney that you have memorized this, so that when you show up in the courtroom with a self-represented litigant, it's the first thing that comes out of your mouth. It's kind of like when they file motions for summary judgment and they spend the whole first page telling you what the standard is for a motion for summary judgment. And yes, there is case law that says this, but the case law, this is from a 1983 decision, the case law subsequent to this has certainly walked away from this. And I believe that under our current state of law, and you know, we're all required to follow those appellate decisions even when we know they've got it wrong, but we're still required to follow them. The appellate decisions have walked away from this, and certainly our code of ethics has walked away from this. So I believe that this is no longer the proper approach to take if you are presiding over a case involving a self-represented litigant. The first instance we had where they started walking away from it was in the White case, and it admittedly was in the dissent. But you saw Judge Langford recognize that courts do not treat a litigant fairly when they insist that the litigant, unaided and unable to obtain the services of a lawyer, negotiate a thicket of legal formalities at peril of losing his or her right to be heard. Such a practice manifestly excludes the poor and the unpopular who may be unable to obtain counsel and obtain access to justice. So clearly they're walking away from the principle that you as a self-represented litigant are held to the same standard and we're going to treat you the same as if you were an attorney. If you choose to represent yourself, that is the peril and the risk that you undertake. And we have to recognize that the self-represented litigants who appear in front of us are not self-represented in the vast majority of situations by choice. They are self-represented because they have no other option. They can't afford an attorney. And there's been much talk about how Washington has this program now where I call it paralegals on steroids, where they kind of are a little bit more than a paralegal but less than an attorney, and they can represent clients. And should Arizona have such a program? And what I like to point out to people is putting aside whether we should or should not have that, it's not going to help our self-represented litigants. Because it's not like they can afford $200 an hour, but they can't afford $500 an hour. They can't afford $200 an hour. They can't afford $150 an hour. And these paralegals on steroids, they're in here as their profession. They're not doing this for free. This is their livelihood. So they're going to charge for this service. And many of the people we see are not going to be able to afford them any more than they can afford an attorney. In the materials, there's additional quotes from that case, from the dissent, but then you move to the Finley versus Lewis case, which is a 1991 appellate decision, and this is not in the dissent. Now, they're quoting from another case, but it's in the Court of Appeals decision. And there the Court of Appeals says, again, not in the dissent, meaningful access to the courts imposes an obligation on the part of the court to make reasonable allowances to protect pro se litigants from inadvertent forfeiture of important rights because of their lack of legal training. That right should not be impaired by harsh application of technical rules. I believe this is the current state of the law. So when the attorneys in your courts who are up against a self-represented litigant want to cite to you from the 83, 81 decision, the one that you hear every day in your courts, the Copper State Band versus Saggio, I would ask them, well, what about Finley versus Lewis? And see if they're prepared to respond to that. Now, I spoke at the State Bar Conference on access to justice issues, and I had someone from the audience say, well, if you're there and you're helping out an unrepresented litigant and you're not providing the same assistance to the party who's represented, you're really creating an unlevel playing field, an uneven playing field. And my response was, when I have an individual in front of me who's got a college degree and a postgraduate degree from an accredited law school, and an individual on the other side who doesn't even have a high school education, there is no level playing field. What I'm trying to do is create the level playing field. It's no different than if I want to go out and play golf against Jordan Spieth. That's not a level playing field. I've probably played golf far more years than he has, but there's no level playing field there. So how do you level the playing field? You put me on a different set of tees. You put my handicap into play. You make him give me at least 2 shots on every hole. Then we might start having a level playing field. But putting me up against someone who that's their livelihood, that's not the level playing field. So I don't feel like we are creating an unlevel playing field when we help self-represented litigants. I feel that what we are doing is helping to create that level playing field. And as I said, it's not only the case law that recognizes the need to provide assistance, it's also our code of ethics. So if you look at Rule 2.6, ensuring the right to be heard from our Arizona Code of Judicial Conduct, it says that a judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. And the comment specifically addresses that their substantive rights can only be protected if their right to be heard is observed. So these litigants have a right to be heard. They deserve assistance in assuring that their right to be heard is recognized in our courtrooms. The Rule 2.2, impartiality and fairness. A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. And again, the comment recognized it's not a violation of this rule for a judge to make reasonable accommodations to ensure self-represented litigants the opportunity to have their matters fairly heard. So basically it boils down to, and there's some more quotes in here that deal with the need to make sure that self-represented litigants have access to justice. So it boils down to what can you do? What should you do? What can you ethically do to make sure that the facts and law are before you without being or being perceived as non-neutral? So how far can you go with a self-represented litigant? You know, the viewpoint I've always taken, and I discussed it at our judicial conference this year, and I know some of you were there, is if I have litigants who leave my courtroom and believe that they have received the rights that they're entitled to under the law, I don't know how any side can leave and say I was treated unfairly. If I got what I was entitled to under the law, how was I treated unfairly? And so that should be our objective. So if you have self-represented litigants in front of you, and I know you're going to get scenarios this afternoon that perhaps have missed an element, I have no problem asking them, do you have any evidence on this issue? You know, this is one of the elements you have to prove to me. Do you have any evidence you want to give me on this issue? There are articles in your materials that I think are very good articles, and they talk about techniques you can use to help assure. Are the techniques coming up?
Yes.
Oh, one at a time. There you go. To assure that your self-represented litigants have access to justice. And one of them they talk about is framing the subject matter of the hearing. You know, and I'm going to give you analogies that I used in family court cases because those are the types of cases that I dealt with that had extensive representation or lack of representation by lawyers and self-represented litigants. And so typically if I've got parties in front of me and it's perhaps their first hearing in front of me, I'm going to try to explain to them at the outset what's going to happen at this hearing, whether they're both unrepresented or only one's represented. The purpose of this hearing, we're going to do a resolution management conference. The purpose of this hearing is to determine, have you reached any agreements? If you haven't reached any agreements, then we're going to set this for a trial where you're going to present your evidence to me. If you can't reach agreements here today, I can't hear conflicting testimony and make a ruling. I'm not allowed to do that under the law. So all we can really talk about is if we can reach any agreements here today. So let's talk about what the issues are in your case. And then I would go through what the issues are going to be in their case, depending upon whether it's a case with children or without children. Is it a paternity case or is it a divorce case? So I would identify the issues. And as I identify them, I'd kind of go over what the law is on each of these issues. We're going to talk about legal decision making. The law encourages both parents to be actively involved in their children's lives unless there's a reason why they shouldn't be. One reason might be substance abuse. One reason might be criminal convictions. We can talk about those, but that's where we start at. Here's what legal decision making is. Who's going to make the primary decisions involving your child? Medical, educational, religious, personal care decisions. These are the significant decisions. We're not going to decide whether the kid wears khakis or blue jeans to school, whether it's a pigtail or a ponytail, whether it's a hot dog or a hamburger. We're talking about major decisions. So I would try to explain to them each of the areas and what the law is that's going to apply to those areas. And that goes along with explaining the process that will be followed. Like I said, I'll tell them at the beginning, this is not an evidentiary hearing. All I can do at this hearing is see if we have agreements. If we don't, then I'll set it for an evidentiary hearing, and I'll work with you to come up with a date and time that works on your schedule. Eliciting the needed information from the litigants. So oftentimes after I've gone through with them, for example, what each of the issues are going to be in their case, I'll start with, okay, let's start with legal decision making. Now I had a vested interest in starting with legal decision making because there's 23 factors I got to go through one by one by one if they can't reach an agreement on legal decision making. If I can get an agreement on legal decision making, I don't have to go through those factors. So I want to try to get an agreement on legal decision making if I can. So I'd start with that. And then I would turn to each one. Whoever filed the petition for dissolution, let's say it was Mom, I'd turn to her and say, Mom, you know, what do you think? How about joint legal decision making? Where you both work together to reach decisions. Is that acceptable to you? And then maybe she'd say, yeah, I can live with that. Dad, is that acceptable to you? Well, no, I want sole. Well, Dad, tell me why you want sole. Tell me why you think that would be better for your child. because everything here we're going to do in the best interest of your child. So tell me why that's better. So I would try to engage them and get them going in the discussion. If push comes to shove, maybe I'd try to get temporary orders in place. Well, why don't we try this temporarily and see how it works out? And if it's not working out at the trial, we can look at adjusting it. But are you willing to give it a try? Are you willing to at least give it a shot for a couple of months and see how that goes? So, you know, I tried to work with them in more of an engaging format rather than tell me what your position is, tell me what your position is, okay, you don't have an agreement, I'll see you in 6 months. Oftentimes you can reach agreements, particularly once they understand what the law is. You know, like particularly if you're talking about dividing assets in family court or dividing debt, because it's divided without regard to fault. So they want to come in and tell you everything she did that was terrible, and they want to come in and tell you everything he did that was terrible. And you can kind of walk them away from that. Well, I understand how you feel, but under the law, I got to decide this without regard to fault. And I would expect that you want your judge to decide things under the law, don't you? And get some buy-in on it and kind of spoon feed them down that road. And it helps keep them focused. Again, involving the litigants in the decision-making. What do you want? Tell me why you want it. Tell me why you think that's in the best interest of your child. And I know I'm using family court, which you don't do, but you can use these same techniques and mechanisms in your eviction cases, in your cases that have the self-represented litigants. They will feel that they've had the opportunity to be heard, the right to be heard. They will have had procedural fairness if you engage them in the process. Now, they may say a lot of things that you know aren't going to amount to a hill of beans in your decision, but if they have had the opportunity to vent that out and feel like they've been heard, and you can explain to them why under the law that may not work, they're going to leave much happier than if you just cut them off at the knees and say, not going to hear that, let's move on. Articulating the decision from the bench. This is recognized as a best practice. It depends on who I have in front of me, whether I go down this path or not. If I have someone that I know is going to go ballistic when I rule, or is now going to want to re-argue everything, I'm probably not going to rule from the bench. I may have articulated to them what the law requires, but my final ruling may come later in an under advisement. Just because if I've gotten them calmed down a little bit, I don't want to rile them back up again and have them leaving the courtroom yelling at each other or yelling at me. So you kind of have to play it by ear, I think, on that one and read your audience. If you have someone that's working with you, reaching agreements, it's easy to say, and at the end I always sum up, because we would do a Rule 69 on the record where we get them to avow that they're doing this on their own free will, and one of the scariest questions you have to ask them is, has anyone coerced you to do this? Because you're sitting there hoping they don't say, well, yeah, you did. So you're kind of sitting there saying, oh, please don't say me, please don't say me. You know, so we have to do that at the end, but otherwise, and even if we didn't have to do that, I always sum up for them. And now here's the agreements we've reached. We've agreed that we're going to have joint legal decision making, and you're going to talk to each other and work with each other. We've agreed to that, right, Mom? Yeah. Right, Dad? Yeah. And here's the parenting plan we've put in place. We've agreed to do this and this and this. Right, Mom? Yeah. Right, Dad? Yeah. So you kind of get the buy-in, and then they leave the courtroom knowing what's expected of them. Explaining your decision and summarizing the terms. I kind of just went over that with you. That's what I try to do at the end. Maybe not explaining my decision as much as just making sure that they understand what their obligations are when they leave the courtroom. You know, we're going to come back on this date and you're going to bring your evidence. You understand that, yes. And you got to bring to me everything you want me to consider at this hearing, whether it's bank statements or pictures or recordings. You need to bring these with you. You understand that? Yes. And you need to give copies to the other side. You got to give them so many days in advance. So I kind of walk them through it and spoon feed them the information. Anticipating resolving issues with compliance. You know, are there going to be any issues if we do the exchanges this way? Is this going to create any problems? Because sometimes you'll find that there may be issues, but because you have the black robe on and because you're sitting up there higher than they are, they don't want to tell you about it. But if you flat out ask them, then you might find out about it. But otherwise, they're like, oh, maybe this is a stupid question. Maybe I shouldn't be asking this. So you kind of want to encourage them to get that out there. Providing the written order at the close of the hearing. I do not typically do that in family court just because it's right now, I cannot get that done. If they wanted to sit and wait, they could certainly do it, but they'd be sitting there for 4 or 5 hours probably, because I'm going into another hearing and I don't have staff to create that written order. But it is important that whatever you provide them in writing be written in a way that they can understand it and be specific. Because if it's not, they're going to find that loophole or they're going to be confused. Well, it says mom gets the child on Mother's Day, but what time do I have to give the child to mom on Mother's Day? It doesn't say what time. So is it noon? Is it 8 o'clock in the morning? You need to have the specificity in there for them to understand. Setting the litigant expectations for the next steps. I kind of went over that with you when I explained to them what's going to happen at the next hearing. What do you need to bring? What do you need to do before that next hearing? Now, I'm not claiming that I have any kind of special talents, and I do not delude myself into believing that they leave my courtroom understanding everything I've said. I think they nod along sometimes just because they know they're supposed to say yes, and then they leave the courtroom and say, what the heck did she say, and what am I supposed to do? So that's why I try to make sure the written order is there. But, you know, it's kind of like the infomercial mentality. The more times you say it, the more times you say that phone number, the more times, the greater the likelihood they're going to remember it. So the more times you say it to them, explain it to them, the better likelihood they're going to remember it. Effective use of nonverbal communications. You know, guys, you're on your own on this one. I am not good at this at all, because all of my nonverbal communications are usually when I'm glaring at people. So I don't have the warm, fuzzy, let's all get together and hug kind of nonverbal communications. It's usually more when I'm looking at them like, well, what do you mean you don't understand what I'm saying? So you're kind of on your own on your developing your nonverbal communication skills. I think we all need to understand that this need to assist self-represented litigants, to provide them with access to justice, is not just our responsibility. It's also the responsibility of our courts, and it's the responsibility of our staff. I think that the justice courts are doing a great job on the court-wide level on the access to justice issue. They're in the process of revamping all of their eviction forms to put them in plain English. Judge Creo, sitting in the back, has been very, is not going to look up and acknowledge this, that she's doing this, has been very instrumental in rewriting these forms. I have them all in my little folder here because I need to be reviewing them and providing her input. But that's how your court can provide access to justice. Is there the ability when they walk in your doors to find the forms they need, to understand those forms, to know what processes to follow? Are there people there who can help them if they have questions and answer those questions and assist them? You know, because we call them self-help centers, and I'm not a huge fan of the term self-help because it suggests that here it is, help yourself. I like to think of it more as a resource center, a place where we can send self-represented litigants where they can obtain the resources and assistance they need to represent themselves, to provide you with forms that make sense, pleadings that make sense, the correct pleadings, to not have them rejected by the clerk's office, which I'm not criticizing the clerks, that's their job, but because they're just missing an I here or a T there. We need to make sure that they get assistance at the ground level. And then there's the staff. And I will tell you from being on family court, I I must have heard my staff say 50 times a day, "I'm sorry, I cannot provide you with legal advice," when these self-represented litigants would call on the phone. "I'm sorry, I can't interpret the judge's ruling for you. I'm sorry, I cannot provide you with legal advice." That's a correct statement. My staff cannot provide self-represented litigants with legal advice. But not everything they're asking us for is legal advice. There's a difference between legal information and legal advice. And I think too often our staffs, our courthouses, just go to the default position of saying, "I'm sorry, I can't help you, I can't give you legal advice," when in actuality they could help them. They want to make sure they're not stepping over that line. You know, we're working to try to address that by trying to come up with answers to commonly asked questions that all courts can utilize, so that hopefully we're all providing the self-represented litigants with the same information and we know what answers we can provide. But the guideline I always tried to use for my staff when I thought that perhaps they were using that term a bit too often was to remind them that anything that's on our website, we can tell them. If we can push that out on our websites and tell litigants in a website forum this information, why can't my judicial assistant say that? So if it's information that we put out there, how to fill out this form, how to find this, where to go to do this, what you need to modify your child support, if we can put that on our websites, we can certainly provide that information to the litigants when they call on the phone. So that's kind of the rule of thumb I would use with my staff. If they had questions, look, is it on our website? Well, just read to them from what's on our website. Pull up our website on your machine and you can read to them from what's on the website. You don't always have to say, "I can't give you legal advice." There may be times when you do have to say that, because there are times when they're asking for legal advice. But it doesn't have to be the answer that's given every time. There are sections in the PowerPoint on what your employees can do from the Code of Judicial Employees. And I would encourage them to take a look at that and make sure that they stay current with that information. I don't think it hurts to take a look at it on a regular basis, because I do believe that it just becomes too easy for them, and they're busy and they want to get the person off the phone because they got 3 other calls where the lights are blinking and they've got work piling up in their inbox, and sometimes it's just too easy to say, "I'm sorry, I can't help you, you're asking for legal advice and I can't give legal advice." I'm going to finish up by talking about one of the areas our court is exploring right now and that we're getting ready to put into place, and I'm hoping that we can incorporate the justices of the peace courts in this process as well a little bit down the road. But we are implementing an AmeriCorps program through an AmeriCorps grant where we're going to have individuals, they're going to be college students, we're hoping, in our self-service center that will actually work with self-represented litigants and help them fill out forms, walk them to the clerk's counter if they need to file something, walk them up to the courtroom if it's an order of protection, review the forms to make sure they're done correctly so they don't get rejected at the clerk's office. We will utilize them hopefully to assist in classes that we can provide to self-represented litigants. We'd like to be able to maybe on some kind of, not daily, but regular basis, perhaps come to the justice of the peace courts and work with the self-represented litigants there on how to fill out forms, whether we do it in a classroom setting or otherwise, but how to fill out your eviction papers, your responses, what to do in these cases, what you need to bring to court. But I think there's a lot we can be doing that will make your jobs easier and ours as well in assisting these self-represented litigants. The other thing I wanted to close with is I understand that self-represented litigants push your buttons. I fully understand that. Been there, done that. They can drive you up a wall. when you're in the courtroom, because you can't get them to focus. You can't get them to zero in on what the issues are. They're mad. They're not mad at you, but they're going to take it out on you. And so I fully understand that these can also be extraordinarily difficult individuals to deal with, and that this is your life. Although I will tell you, sometimes I thought that dealing with the self-represented litigants, particularly if both sides were unrepresented, was not nearly as difficult as dealing with the cases where they both had attorneys. Sometimes those were more difficult to deal with than the self-represented litigants. But I understand they push your buttons. But it is an area you're always going to have to be cognizant of and aware of, particularly now when all of our courtrooms are recorded. While you may not feel like you're treating that self-represented litigant rudely or disrespectfully, the video may tell a different story. So I think that's the other thing we really have to be aware of now. The video helps us to a very large extent, because in many cases the video will show that you did not do what the self-represented litigant is claiming you did. I had one where they said, well, she just kept telling me to shut up, shut up, shut up. Well, they watched the video. I never used that phrase the entire hearing. Did I tell him to be quiet? Yes. Did I tell him he would have his opportunity to speak, but it was not now? Yes, but I never told him to shut up. So the video can be your friend as well. It can support you in what you're doing. But demeanor is always going to be a huge issue in dealing with self-represented litigants. And demeanor, if you come out and you're already have that chip on your shoulder because you're having a bad day, and now you've got the self-represented litigant, and oh my gosh, not another one. I've already had 20 today. How am I going to deal with this? Let's just get this over with. They perceive that. And that is not procedural fairness to them. And so they will start reacting to that as well. So those are my tips and pointers. We all have our own personality. Sometimes things that may work for me may not work for you. But hopefully you can see the overall gist of what we need to do to assure that these individuals have access to justice. I have no problem asking questions of self-represented litigants. I have no problems if I believe they've left something out, pointing that out and asking if they have something. If they tell me they do and it's at home, I have no problem giving them a week to get that material to me. My objective is to make sure that they get what they're entitled to under the law. And if that's what it requires, so be it. Having it on my calendar for another week's not going to kill me. A week goes by, my JA comes in and says, here's what you got, or nothing came in. And then I can issue my ruling, which is probably already typed up, with just that one little area missing. So I don't believe that that's acting unfairly. I don't believe that that's creating an unlevel playing field. I believe that's providing self-represented litigants with the access to justice that they deserve and that we should make sure they get. So, do you have any questions? Yes.
Do you find it easier to deal with self-represented litigants when both sides are represented as opposed to one side represented?
Correct, I do. And that's because the question was whether I find it easier to deal with two unrepresented litigants or cases where I have one that's unrepresented and one with an attorney. To me, I find it easier to deal with two because I can tell them at the outset. If I feel that information's missing, Dad, I may be asking you some questions to try to get that information. Or Mom, I may be asking you some information or questions to try to get that information. So that when I ask the questions, they know why I'm doing it and I'm not favoring one side over the other. And I might start out the question with, Dad, I didn't really hear anything about this. Can you tell me something about this? Or is there anything you want to tell me about this? When I have a side that's represented, how far do you go with the attorney? I'm not there to do the attorney's job. I once had an attorney tell me that, well, their suggestion was that if you have one side represented and one side unrepresented, that the judge should ask the questions on direct of the unrepresented, which typically I would not do. I would just say, tell me what you want to tell me. This is your opportunity to put on the record everything you want to tell me. So what do you want to tell me? And I'd let them go in a narrative form. And if they start wandering, I'd redirect them back. But I wouldn't do it on a question and answer basis. And then this attorney's suggestion was that not only do I, if I'm going to do that, if I'm going to ask the questions and do the direct examination of the unrepresented, I should do the same for the represented. And I was like, what? You know, aren't you getting paid to do this? And am I going to get part of your fee if I do your job for you? And so I do find it more difficult because of that. Where do you go with the attorney there? You know, the reality is, and I'm certainly not encouraging malpractice suits, but represented parties whose attorneys drop the ball have an avenue of relief. A self-represented litigant who drops the ball does not. But it is, but sometimes I will ask questions even when they're represented, but because of that dynamic, I do find it more difficult. I agree, and I don't know how you find it, but I do find it more difficult. Any other questions? Yes. Let's see who it is.
In the event you're hearing a hearing where there's one party that's represented, one party that's not, and the party that's represented fails to establish some factual basis, and it's now the other party's turn, do you let the second party go, or do you stop it there?
Well, that would be more in a civil case, probably.
Or criminal.
Yeah, or criminal. You know, and I will tell you, I usually discouraged, I didn't discourage, that's not the correct word. I made sure they fully understand what they were getting into in a criminal case when a defendant wanted to represent themselves. But in that situation, what I might do at that point in time, it depends. If I'm in a case involving a jury, there's very little I'm going to do in front of the jury because I do not want the jury to perceive that I am favoring one party over the other. They will easily pick up on that. So what I might do is take a break, send the jury out of the room, and then sit down with him and say, you know, again, an element of your case is X, Y, and Z. Do you have anything you're going to tell me on X, Y, and Z? And
Say that to the represented party? Because again, the situation, the represented party didn't meet.
oh, the represented party didn't meet. In that case, I probably would let the chips fall as they may and tell the represented and grant. But you know, you're assuming that the unrepresented party is going to make a motion. If they're not going to make a motion for a directed verdict or a Rule 20 motion, I'm probably not going to do it on my own.
Okay, that was our other question.
Yeah.
Where is that line if they haven't done what they're going to do, you know they're out there to stand up and basically win the case with the other side, you just let them speak?
Correct. And if I have a jury trial and somebody has not provided evidence on an element that they need to win their case, I think the jury will catch that when they go through the jury instructions. And, you know, I will have to say I have great faith in our jury system. Having done jury trials over an extended period and impaneled many a jury, I have never had the jury come back with a verdict where I sat there and said, what were they thinking? How could they come up with this? I always thought that their verdicts may not be what I would have picked, but I could certainly see how they got there. Now, that's not true with some of the questions they ask. Sometimes they come up with questions and you're like, what? But the verdicts I've always been comfortable with. I think juries figure it out.
And that's, well, speaking from justice work, we usually don't have juries. Usually, we're also the decider of facts. So the typical situation is you're sitting there, you're deciding, prosecution's done it, they didn't establish where the person was, the person's about to stand up and testify, they didn't do jurisdiction, just let them go.
If I would probably allow the defendant to tell me what he wanted to tell me, and then end up ruling in the defendant's favor, if the defendant wanted to tell me anything.
Okay.
All right. We do have a 6-judge panel at the end where we can ask lots of questions. Is there anything directed for presiding Judge Barton?
Judge Correa.
Mm-hmm.
Okay, I think you mentioned it before, but I wanted some clarification on it. You know, again, the attorneys are not used to it. They're not going to, it's going to be something they're going to get used to, I guess, for if they're there and there's a litigant representing themselves, to get used to the fact that we are going to make sure they're not misled and that information. Could you clarify again? You mentioned if, you know, they're always wanting to say, well, what about this? What about, you know, that we may be saying too much. Can you clarify a little bit more about that, of what we actually should be saying to the attorney that is there with the self-represented litigant, and we're trying to make sure that this trial goes fair? You know, we'll give information.
Well, usually, my experience is oftentimes the attorneys appreciate me starting out by explaining here, like, for example, my family cases. Here's what the issues are that I'm going to be deciding. Here's what the law is on those issues. Because sometimes the attorneys have tried to explain that to their clients, and their clients think they're not fighting hard enough for them when they explain, you've only been married 6 months, you're not going to get spousal maintenance. You know, he's unemployed, you're not getting spousal maintenance. And it helps if the judge sits there and says, you know, here's what I would have to find in order to award spousal maintenance. So sometimes the attorneys actually appreciate me going into that with their clients. Is that what you're asking, Rachel? I'm not.
Well, that's probably a different case, but we're thinking of eviction. We have eviction attorneys, we have criminal attorneys, we have civil, but especially civil. I think I'm not seeing that yet. They seem to be uncomfortable about us giving more information. That kind of, until they get used to the fact that, I mean, you're right, to explain the procedure in the beginning is probably the best thing, so they know what we're doing ahead of time. But I see some not taking it very well yet.
Oh, and I think you will, you know, because I think attorneys don't always view that their job is to get their client what they're entitled to under the law. I think sometimes they view that their job is to win. This is an adversarial process. My job is to win. And if I can win on a technicality, it's still a win. You know, if they haven't proven an element of their case, or I object to this exhibit and I can keep it out, it's a win. But that's not what our jobs are. And that's what I try to explain to them, is my job is to make sure that your client receives everything your client's entitled to under the law, and this party also receives everything they're entitled to under the law.
Okay, thank you, Presiding Judge Barton. Thank you, Chief Justice Bales.
I may have just muddied the waters.
It's going to get a lot muddier.
And we do have a fabulous panel at the end, and we want to make sure we have enough time for them. So please just take a 10-minute break. We will reconvene in 10 minutes.
All right, thank you very much. We're going to get started again. With me here, I think everybody knows Judge Gerald Williams, and of course Charlie Adornetto's here, and we're going to be going through and presenting the new best practice, but I just want to have the opportunity to have a couple of remarks, and they're prompted by the questions that came up. The question by Judge Kissel, the question by Judge Carrillo, both had me thinking about, recognize that in this best practice, we are deliberately stepping outside the adversarial paradigm. I mentioned it earlier on, but let me flesh that out a little bit. We are so used to, and lawyers are addicted to, the adversarial paradigm. That is where you have a professional attorney and a professional attorney in front of you. And their job is not to focus on the truth. Their job is to focus on maximizing the position of their client. And this one on the other side is maximizing the position of their client. And then you, as the judge, get to sit there basically in a completely passive role and make a call on who who's the best or who has persuaded you the most. That's the adversarial paradigm. And we're stepping outside of it when we're starting to talk about self-represented litigants. And I think that's why it does make a big difference if there's an attorney on one side and a self-represented litigant on the other, because already it's a lopsided approach. But also recognize when you step out of the adversarial paradigm, there are so many rules that we're used to that are derived from the adversarial paradigm that we leave behind. And there's no clear guidelines for us when we do that. And I've been wrestling with this for several months, and the best advice I've come up here is when you step outside of the adversarial paradigm, focus on making certain that you're being fair and you're being even-handed. And you'll have to look at it from a completely new light when you do that. Charlie has put up something that's here on my request, this old phrase about when you represent yourself, choose to represent yourself in court, you're going to be held to the same standards as the attorney. Justice Bales and Judge Barton have given us cover for this, but I'll tell you right now, with regard to a self-represented litigant, that language is nonsense. It's nonsense, and it doesn't apply. And leave it behind, and don't let anybody, don't let a lawyer intimidate you when you're doing what you need to do with regard to a self-represented litigant. It doesn't apply in these situations. So again, we're going to introduce the best practice. It has been adopted by our best practice committee, which Judge Williams chairs, and Judge Williams played a key role in developing it. But the first draft was actually originally prepared by Mr. Adornetto. And Mr. Adornetto was not making things up on his own when he was doing it. So Charlie, would you take a moment and talk about the sources, the original sources of this best practice?
We did a lot of research, thank you, before we implemented this. And so we looked at a lot of source materials, and a couple of them are in your packet, including what we primarily used was Richard Zorza. And when Paul Julian is up this afternoon, he can provide more information about Mr. Zorza. But Mr. Zorza really is a leader in the field of self-represented litigants. And so the first draft of the best practice did rely or borrow heavily on Richard Zorza. What I did is adapt it to the justice courts, because his wasn't specifically drafted for the justice courts. We also looked at the ethics, and you'll see there's an article from the Notre Dame Law Journal on ethics of judges in this new paradigm. And so that'll be important when we look at some of the ethical issues that we'll be talking about this afternoon. And before we proceed, just a couple of housekeeping matters. If we are recording this, video and audio, and unless your question is on a microphone, it's not being recorded. So Cheryl is going to run around for this session with the microphone. If you do have a question, raise your hand and wait for Cheryl to get to you. And this PowerPoint is not in the materials. What it does basically is go through the best practice. There's a little additional material, but not much. So please turn to the best practice in your materials, and that is what we will be relying on here.
Okay. Gerald, you're up.
Oh, this is, I get the slide that has 300 words on it. Okay, awesome. My goal for this is actually, I mean, just to sort of give an overview of the best practices, you have the actual best practices policy in your material, but I kind of want to rush through this because I want to make sure that we have enough time to do the scenarios. It's sort of like trying to teach evidence. You can put the rules of evidence on the slide, but it doesn't really work unless you do examples. And I think this is material that really only works with example.
We got to cover the basics, but the scenarios are when it's going to get exciting.
Yeah.
Okay.
So I guess hit return here or clicker or somewhere. I don't. Okay. But again, and this is stuff we've already talked about, and it's not really a standalone concept. It's something that has been sort of evolving for quite a while. The first thing that happened in this area was when we did the eviction rules. At the time, Arizona, and we still may be the only state that has residential eviction rules. And we did those in large part to sort of codify what people knew as happened. The only place you could find out what happened in an eviction case in Arizona was to get a hold of the script that was passed out at new judge orientation. And that's perhaps not the best way to, disseminate information. So we had the eviction rules, and we had the Justice Court Rules of Civil Procedure, which I had some concerns about initially, but those turned out to be a really good product. I had concerns about going on, down this road on the self-represented litigant stuff too, but it's turned out to be, I think, a very, very good product. But it's sort of it's not just, oh, we decided to do this all. It's been sort of a whole process that a lot of different people have been involved in. And as you already saw, it ties in directly to the Chief Justice's strategic plan, and he already explained how those go through. We obviously want to promote access to justice.
You actually emphasized that today.
True. And so if we could just maybe, again, and you've seen this material before already today as well, both through the Chief Justice and through our presiding Superior Court judge. Again, there is legal authority for this. We're not just making it up. And yes.
Although it wasn't mentioned this morning, but Rule 2.8b, a judge shall be patient, dignified, and courteous to litigants as well.
Yeah. And this is one of the cases that sort of started it, but there's an article on this case in your materials that was already described, and there's the site to the Notre Dame Law Journal article. It's in there as well.
But also, if you have not read Turner v. Rogers, I strongly encourage you to do it. It's not necessarily the kind of case that we're going to confront. It was a child support case. But who was the author? Which justice? The justice who authored it took a very, very strong stance in terms of what the Due Process Clause requires of judges when somebody is standing before them and they're representing themselves. The Due Process Clause requires a judge to make certain the person understands what's going on and is treated fairly. And Turner v. Rogers is the clarion call for action to support self-represented litigants in getting a fair shake.
The slides are broken down, or the material is broken down into things like beginning the proceeding and managing evidence and stuff like that. And one of the things, and it's a really simple idea, but it took me a while to realize that you can't really be mad at people for not following the rules if you don't tell them what the rules are. And as silly as that sounds, it's a very, very basic thing. And so at the beginning of an order protection hearing, I'll say, we're only going to talk about what's in paragraph 4 of the petition. We're not going to decide who's a better mom, who's a better dad, who's a better, boyfriend, who's a better girlfriend, who's a better husband. We're not going to decide those issues today. We're just deciding this issue, and that's it. And that helps sort of focus things. Now, a lot of the examples and a lot of references in the material include criminal stuff because a lot of these same concepts apply when we're facing criminal things as well. But the best practice is specifically designed just for civil. We may write a criminal one at some point, but criminal obviously has a lot of extra considerations that we're not maybe completely prepared to go into today. But a lot of these techniques will work in criminal as well as civil cases.
You didn't cover recording all interactions.
That's true.
Keep the FTR on at all times.
It's really your friend. Almost always. It's always your friend because people will allege outlandish things, and the only thing you have to back it up is because you won't remember the case because we see too many people. So
it's also painful but useful for you to observe yourself from time to time on the FTR.
And we did feel that it needed to be included here because there are judges who don't record everything with the FTR. And as Mr. Reamer, I'm sure, will confirm this afternoon, many times the record is your friend. And I also included a link, a cite to Rule 17.5 of the Arizona Rules of Criminal Procedure, because I did have someone coming in when I was a pro tem, and he was complaining that he was forced to plead guilty to a criminal matter, and went to pull up the FTR. It's not on FTR. I don't have a clue what occurred then. So it is our friend. It is to our benefit. And in the new pro tem policies, it will be mandatory for pro tems to use the FTR at all times that they're in the courtroom.
I already gave a order of protection example to, again, just announce what's going on at the beginning. Everyone does civil pretrials a little differently. Some people don't expressly do civil pretrials. They set everything directly for mediation. But I tell people at the beginning that, I said, the purpose of a civil pretrial conference is to check in on the status of the case, see where it is, and see what needs to happen next. And they go, oh, okay. So, and then it sort of sets the tone, and we can talk about where they can settle that day. We can talk about a couple other things. But if you don't tell them what the rules are, then their expectations might get frustrated.
And there is also, those two examples are in the best practice. I don't think we need to read them to you, but they are there.
Yeah, and in the trial itself, I have a really long example that I give at the beginning of trials. I explain, I go through the entire order of the trial. Both sides will do an opening statement, then this is going to happen, then this is going to happen, and this is what cross-examination is. And when you're asking the other side questions, just ask questions. It's not a time to argue or debate. I tell them not to do anything they see on afternoon TV judge shows, and they usually laugh. And then, but if you don't tell them, if you don't set that groundwork, then your trial will start to dissolve into a committee meeting, and it just doesn't work, as most of us know.
Now, Gerald and I disagree on one point here, but I think it's a fair disagreement. But if I'm doing a civil trial and both parties are unrepresented, I prefer to do the opening statements for them. Opening statements by a self-represented litigant tends to go all over the mat and get into a lot of unnecessary things, and I hopefully have read the complaint and the answer, and I go out and I say, Mr. Plaintiff, I understand your case involves this, and you're claiming this, and this is how you want me to rule. Am I right? Yes. Okay. Now, Mr. Defendant, my understanding is you say, no, that's not so, that these are actually true, and I should deny him what he's wanting. Is that right? Okay, great. There are opening statements. Now, I want to hear some evidence. I want to put some flesh on this skeleton. So, plaintiff, call your first witness, and that may well be you. But Gerald is going to have him do opening statements.
I put a time limit on it, but it doesn't help. I still end up listening to the direct testimony twice.
Yeah.
And again, this helps a lot on, and the example is from an injunction against harassment, but explain the time that's available, so they know. I mean, and that's one of the things that's odd with us is, as justices, we have no idea on injunction against harassment or order protection hearings. You set them, and you think, okay, well, I'll block off 30 minutes, I'll block off an hour, and then you look at your courtroom monitor, and you're ready to go in, and there are 75 people in the courtroom, all of which expect to testify during this hearing. Obviously, you have a management problem at that point. But yeah, if you tell them what the time limits are and you enforce them, and you even let them go longer, then people just want, well, I shouldn't say they just want an opportunity to be heard, but they obviously feel like they need to, they want to leave feeling that they got their day in court, whatever that means to them. They want to feel that they got their day in court.
Here's the most useful thing that has happened to me when I established the time limit for this trial. It doesn't happen in every case, but when it does, you're very glad you did that. And I'm talking about that defendant who thinks he's going to prove his case by cross-examining the plaintiff forever. You know, I'll say, I have been known to say, you know, Mr. Defendant, you keep asking questions, and I've told you already you'll never prove your case through cross-examination. I want to hear what you have to say, but you're not on the stand yet. And look at the time, and look how it's going. You can keep, if you keep cross-examining until the time is used up, you will never testify. So maybe you want to move along.
And the important thing about doing this at the beginning of the hearing is no one is going to complain if you decide this needs to run longer, I need to hear more evidence. But if they're rambling, if you don't set a time limit and they're rambling on for an hour and all of a sudden you decide 5 minutes, you got, then it's worse. So if you set a time limit at the beginning, you're free to go over it and they're not going to complain. But if you impose a time limit somewhere in the middle of the case or toward the end, that's when you run into problems.
Good point, Charlie.
Well, this is, again, tell what the governing law is, tell what the evidence is. I had a person, I told this example to some people earlier, I could tell at the pretrial conference that he was likely to lose a trial. And I sort of tried to get a settlement, and it didn't go well. So I actually went and printed out the jury instruction for res ipsa loquitur and handed it to both sides. And I said, okay, you have to, this is what you have to prove. You have to prove this stuff. You have to defend, attack this stuff that he's going to try to prove. And it sort of helped. He still was mad at me when he lost at trial, but at least he had some guidance. I find that, and I don't know what other people's experiences are, when you're doing orders of protection hearing, people generally know what the term harassment means. People almost never know what the term violence means. Obviously, in Arizona, domestic violence means a lot of things other than just a Webster's definition of violence. So I tell them, I said, this is different than, you don't have to chase someone around with a pickaxe, for it to be domestic violence. Harassment by text message, if the relationship is such, can be domestic violence. And that way they don't structure the entire case of, I've never hit her, I've never hit her, I've never hit her. No, you just send her 80 text messages every day. So that's something that I found to be useful. Charles, do you have any?
I think that this is an important thing, especially, and when we were doing the scenarios, it was hard to come up with pure civil scenarios because we've all been there where you've got two pro pers on each side and they don't have a clue what they're doing. They don't have a clue how to put in a case. They don't have a clue how to prove a counterclaim. If at the beginning of the proceeding you explain, and as Judge McMurray indicated, he would do it in his opening statement with, I believe you have a breach of contract case. And if that's the case, then you need to prove an offer, an acceptance, consideration, and go through the elements. And it will make your life easier if you do that at the beginning and help people to focus. And again, for an order of protection, that I'm not determining who's a bad person, just whether or not this order of protection needs to be in place. Any questions thus far? Okay.
And again, on the simple language and invite questions, the best analysis actually, or example I've ever heard on our eviction cases was Judge McMurray uses the example of fishing. Every now and then you've got to stop and say, wait a minute, this one really, no kidding, has some issues. This one really, no kidding. This is different than every other non-payment of rent case I just saw for the last, hour. And what I use, and I actually put it in an article that Arizona Attorney Magazine published, I just say, your landlord's claiming you haven't paid rent for the month of July. Is that true? And they'll say yes. And I just say, why? And you will almost always get some mixture of my landlord is a jerk and a financial hardship story. Neither one of those are obviously defenses to non-payment of rent. But if you just say why, then every now and then you'll get something like, well, it's been really hard since they cut off my power. Wait, what? Now you've got a no kidding issue, legal issue that you have to stop and deal with, and probably that is something that might get set for a trial as opposed to everything else. But if the person approaches and you say something like, do you enter a plea of guilty or not guilty to forcible entry and detainer,
No.
yeah, they're going to look at you like you have three heads.
No. Gerald asked why. I usually say, you didn't pay your rent. Okay. The reasons why you didn't pay your rent, is there some major failure here on the part of the landlord, or is it mostly because you're having hard times financially?
And we talk about using simple language. That does not include Latin. So don't ask someone how they intend to prove their prima facie case. Or provide a jury instruction on res ipsa loquitur.
Well, it was actually that kind of case. But yeah, I had to explain what it was too, but okay. You want to take a matter?
You can.
I'll do it. Again, this is focuses on the people's perception of fairness, and you probably do from time to time have to let people know, I'm going to be asking questions, but if I do, don't think that I'm doing it because I'm leaning one way or the other. I listen very rigorously, and I never make up my mind until the end. But if I may ask one side to explain something and then to come back and ask the other side to explain something. Don't interpret my questions as anything about the decision. I'm going to hear everything before I decide.
This one is very important because we don't want you to leave here today thinking that you can allow pro pers to ramble on with unfocused and with meaningless testimony. You can keep them focused. You can keep them directed. We need to make sure we do it in a calm, peaceful, dignified manner, but you do need to keep them on track. And again, it's not Judge Judy.
Okay, the next one is pay attention and look like you're paying attention. Maybe this is more of an issue with some people. A lot of us just keep our cell phone in our pocket. The first time your cell phone goes off in the courtroom and it's your cell phone going off is probably the last time you bring your cell phone. And maybe I'm the only one that's happened to. You have signs up on your door saying no cell phones, and then yours is the one that goes off, and you just sort of pretend that it's not there and go on. But yeah, you have to look. You have to. And a lot of us are very tech savvy. You're taking notes on the computer. You're doing all this other stuff. You have to make it look like, or explain that, hey, I'm going to take notes on the computer, I'm doing this, or all this stuff. The entire order protection is in the computer. That's why I'm focusing on that. But I really am listening to you, so, please don't think I'm being rude or something like that.
Okay, so here's the truth. About once every 2 or 3 months, I'll be on the bench and I'll say, excuse me, ladies and gentlemen, but there is a crisis going on, and if this phone rings, I'm going to have to take it. But I'll get up and leave and I'll come back, and you got to forgive me for that. But I am here now, and I want to hear what people need to say to me. So let's get this started. And that does happen, but it's an exception to the rule. But I would never answer the cell phone while sitting on the bench. If it rang, I'd say, excuse me, I'll be right back.
And again, unfortunately, this step was here because it was necessary. We have had judicial officers answer their cell phone on the bench.
And have conversations and negotiate the purchase of a car while in the middle of a trial, while people sitting around waiting, and it's all on FTR.
And here's a funny story. I'm in court and I hear some music, and so all right, cell phones off, please, and it stops, and then a couple minutes later it turns, okay, cell phones off, please, and then I realized I was wearing my Christmas tie that plays Jingle Bells, and I was leaning forward and setting off my tie, so. My bad.
The next section's on managing evidence in the courtroom.
So any questions on beginning the proceedings? Good. Wait for the mic.
Wait for the mic, Clancy.
Charles, you'd solve the solution if you just didn't wear that damn tie.
Well, I only wear it in December.
All right, permit narrative testimony by a self-represented litigant. You know, this is, and I think of the times when I've told a defendant to stop asking questions, this is getting nowhere, but then now they're up, I bring them up, I swear them, I sit down, and I tell them, look here, talk to me, tell me what I need to know about this case, and just let them go, and let them go for at least 5 minutes before I start redirecting.
And this is, I mean, obviously we're going to, when we're hearing a case, we're going to pigeonhole, we're going to immediately think, okay, I need to know this. You know, it's an, this is a criminal example, but maybe it's an order protection case and you're hearing a misdemeanor trial. You need to know if the person, you need to know if the defendant was served. And so when the first witness comes up and he's a law enforcement officer, you're waiting for, you know, the prosecutor to ask him, was the person served? This is sort of the same thing. You just say, hey, you know, I need to know about this. And this is a very artful way, I can't remember who wrote this, it wasn't me, the example, but to ask, you know, as opposed, because it's awkward, you know, so were you dating? Did one of you think you were dating? You know, or is this kind of, it can kind of be awkward sometimes in orders of protection.
Often in trials with self-represented litigants, the self-represented litigant will call somebody to the stand and just start asking them questions, going to the heart of the matter. And I stop and say, wait a minute, before you go there, witness, you know, who are you in this situation? How do you know what happened? Were you there personally? Did you see these things? Okay, great. Now ask your question. It's like laying the foundation for a self-represented litigant or a testimony or something like that is often necessary.
Okay.
Okay, the next step is to ask questions concerning the nature of the evidence and avoid not admitting evidence for overly technical reasons. And that note, Judge Williams wanted put in there, so Judge Williams can explain that.
Oh, I think this is hard. I think this is, because I worry if at some point you're just helping one side present their case. And I'll use the phrase, you know, I can't be your lawyer, but you might want to offer some of the documents that appear to be on your table. You brought them to court for some reason, you know, what are they or something like that. But people come up and you don't have, under the rules of evidence, you don't have to have the person who took the photograph in order to admit the photograph, but you have to have something. And so the person just says, well, you know, here's a picture, and the other, maybe there's an attorney on the other side that says objection foundation. Well, if it's maybe a failure to return a security deposit case and it's a picture of carpet that has stained or damage or something like that, you actually need that evidence. And so what I had come around to, it was slow to come around to, is I'll go ahead and not worry so much about the foundation objection, and I'll ask questions of the, you know, who took that photo, when was it taken, did it, you know, was it the condition on move in, was it condition on move out, you know, how is it different, all those sorts of things. I'll go ahead and essentially ask foundational type questions and then have it come in. It gets tricky if they're two, and the attorney, if there's an attorney, he'll probably just be frustrated. If it's two self-represented litigants, then they'll say, well, wait a minute, you're helping them. And you'll say, well, I'm not, you know, I'm not helping them. When it's your turn to admit stuff, you can admit stuff too. But I think it's tricky.
Also, what this brings up, and you've all seen this, if you've been observing, and you've seen it, these parties think that we have studied what's in their disclosure statements. And often you have to tell them, look, I don't look at your disclosure statements. if you want me to consider something that you've disclosed, you still have to introduce it here today for me. I'm not going to look at that. So consider what you need to put in front of me now.
Just kind of an aside, one of my pet peeves here, we have new prosecutors who apparently don't know that we don't have the police reports, and so we're at a trial and they waive their opening statement, and like all you have is a site. It's like, excuse me, but I do want a couple-minute opening statement. I'd like to know what the case is actually about. We have a question? No.
Judge
So,
Carrillo.
can you clarify technical, the overly technical reason? And I want to, what's the example regarding it may be and what would not be appropriate on the other?
Person moves to introduce a photo.
Okay.
Attorney says objection foundation. What he's basically saying is, you know, the standard for admitting a photo is you determine who took the photo, when it was taken. There may be another one of those basic questions, but the main one is this photo live witness? Does this photo fairly represent what you saw that day? Those are all foundational questions to admitting a photo. So what we're basically saying is if the self-represented litigant moves to introduce a photo and the attorney says objection foundation, you don't simply say sustained and move on. Now, I personally hate the objection foundation, and I routinely say to the person making it, counsel, exactly what foundation is missing here, and let them explain it, and then turn to the self-represented litigant that's offering it to have him fill it in.
All right, can you tell me then what would be the one that would be appropriate? Because you have may be and may not be. I mean, the self-represented litigant wouldn't even know that anyway if there's two people, would they? About foundation and...
No, a lot of attorneys don't know what's going on with regard to foundation. No, the self-represented litigant would do it. But what is one that is not overly technical? Hearsay. Okay? And I would, and I have many times explained, you know, I'm only going to listen to people who actually saw or heard what was going on. If you're going to tell me what somebody else told you happened, no, we're not going to hear that. We can't hear that. You got to get that witness in here. So that there is, and you know, basically, Rachel, it's what is both fair and accurate. I mean, we don't allow hearsay in because it's not reliable, you know. With regard to foundation on a photo, well, the question is whether or not it is a reliable photo or not. So get into the foundation there.
Judge McMurray had that exact thing yesterday. And it was a criminal case the state was prosecuting in a self-represented litigant. And he tried to bring in a photo, and the first thing the state did was object to foundation. Well, the defendant didn't have a clue what foundation meant. This was something underneath a house block. So I explained to him, or reminded him, that when the officer testified, the foundation was set on, was the officer qualified to, why was the officer qualified to be a witness, and why would they, some foundation had to be established to use the photo. Well, he got it, and he was able to explain it. So if you give them an example of what's occurred in court, then they quite often are able to do that. On questioning, the same thing happens. Quite often a defendant, a self-represented person, will ask a witness questions, and then all kinds of stuff comes out of it that they didn't really want to have said. And so I will say to them, you know, attorneys in court have a pretty good idea when they ask a question what the answer is going to be. You just brought to the court a whole bunch of information that we would have never had if you hadn't asked that question. So be sure that you know what you're doing when you ask a question. We didn't give them advice, but we gave them examples of what happened in court so they won't repeat the same mistake again.
Good point.
Okay, next up is probe for details and for clarification. And of course, the most obvious situation, and we've all been in here 100 times, somebody comes in for an order of protection and they look really scared, and they're afraid of this person and they can't articulate why. You need to tell us why you're afraid. And we need to establish the relationship, and we need to establish the act or threatened act of domestic violence. And maintain control of the courtroom with courtesy and respect, help litigants stay focused on matters relevant to the judge's discretion. That ties into what we said a couple minutes ago, that we're not saying you need to let people ramble on.
You also can't let one of the parties do running commentary on what a witness in a witness stand is saying. You got to control that. You can't allow that.
Clarify the relevance of testimony when it is uncertain, and so don't automatically cut off someone. It is possible that it will tie in somehow, and just ask, how does this relate to the issues today? And if you might get a good answer. You can do this one, Gerald.
Okay. There's some scenarios then that are better examples of this, but say you have documents that are maybe repair estimates or maybe a part of a lease, or you have documents that they want to offer into evidence, and they may not comply with the sort of the general evidentiary standard for the business record exception to hearsay, or whatever it's trying to get in under. We see this in landlord-tenant stuff all the time, where the self-represented litigant will just bring a bunch of stuff, the attorney will object, and one easy thing to do is just admit it and say that the objection goes to the weight of the evidence and its credibility rather than its admissibility. It also, quite frankly, eliminates an appellate issue. They can't claim that you didn't admit the evidence, and that's why you ruled against them. So it's just sort of one thing. Now, you can't let a bunch of junk, if you got someone come up with just a ream of paper, you can't let that into the record. But it's just one thing that rather than argue about whether or not this is a true and correct copy of something or whatever, just admit it, say it goes to the weight of the evidence, and then press on.
And again, when we go through the scenarios in our last portion, you'll see one with a tenant with a canceled check, which may or may not be a partial payment. And the next step, this one is the one that Judge Williams and I went back and forth on the most, and
This was a fun conversation.
and as you heard Judge Barton say several times this morning, she's okay with this. So when appropriate, tell litigants when they have failed to establish an important element, and then provide an opportunity to fill the gap.
And this is where I drew my line previously, and I think I mentioned it this morning. My prior line was, and you have some kind of civil case, they haven't established damages, they've talked about damages, they've testified about damages, and you can see that they've got repair estimates and photographs on their table. And what I would do prior to me coming around on this issue, if you want to say it that way, I would just, at the end of their case, I would say, is there any other evidence do you want to introduce? And they'd say, no, I'm done. I'd say, are you sure? Is there anything else? Any other, anything else? No. And sometimes I might even nudge and say, are there any documents or photographs you want to introduce? And then they just say no. And that's where I would say, okay, fine. Because I thought asking the next logical question is, do you have any evidence of damages? I thought that was crossing a line and actually helping them perfect their case. And that's where Charles and I sort of fought with snarky emails and other things for
Not snarky.
Mine were snarky for quite a while on this because because it was sort of ingrained in me in just maybe that you never ever help the other side perfect their case. And then what our presiding Superior Court judge said at the judicial conference, she goes, well, you should worry less about that and whether or not you're making the correct decision based on all the evidence that should be coming in. And I was like, you've got a point, and I can't really rebut that.
The clearest example that I've seen here, and this was actually a civil jury trial. Now, I don't want to get into what difference a jury trial makes right now. I think we will get into it in the scenarios. But suffice it to say that I told this self-represented plaintiff that she could have a jury if she wants to. She has that right. She also has the right to perform brain surgery on herself if she wants to, but I don't encourage it. But she wanted to do it. So we're in front of a jury, and it was these people injured my horse and caused him to die, and they're liable for it. And there was an attorney representing the person she was suing, and she presented a very good case of negligence on the part of the defendant in this case. And then she sat down. And I said, do you rest? And she said, yes. And the attorney immediately jumped up and moved for directed verdict because she'd not introduced any evidence of damages. And I granted it. Because I'd warned her if she was going to walk off the edge of a cliff in front of a jury, I would let her. However, if it had not been a jury trial, I would have said, you're right, counsel. She has not produced any evidence of damages. Madam Plaintiff, do you want to reopen your case now and present some damages? I think that's the right thing to do in those cases.
Okay, we have a question.
As you all know, we have mediation, and when mediation is unsuccessful, we move immediately into a sort of pretrial conference where we simply talk about trial preparation. Judge Barton indicated that she had a case, I think, or it was an example, where she gave an individual an opportunity, as I understood, to provide a document that was not present at trial. So there's been a recent case in my building where the landlord didn't bring the contract, didn't bring the 5-day, didn't bring an accounting, brought nothing. And when it asked by the judge to provide the contract, the lease, she said she didn't have it. So do we give her time to go home and get that after we've told her to bring all of her documents in? I'm a little unclear about that.
I can give you my off-the-cuff answer. The closest thing that I give extra time on is the landlord is there, proof of service for some reason is not in the trial. I'll give until the close of the business day to provide proof of service. Because and then we'll fill out the judgment form. I won't sign it, and then it comes in that way. That's the closest.
We do that too.
Yeah, that's the closest thing I do to that. I think her example was maybe not a good example for trials in justice courts, because family court cases never end. They have just perpetual hearings. And so if you have, you don't have it for this hearing, okay, then you have it for the next hearing. And I think that's maybe a little different than what we would have. I don't think we should ever have a trial where we say, oh, you forgot your evidence, okay, well, you can mail it in. I don't think we should ever do that.
Well, I think there's an interesting line here in terms of an individual who comes to anything, a trial, a recital, whatever it might be, and be prepared. And so when you have someone who comes in who's unprepared, to me it seems as though you should hold them to a certain standard because they're just so lackadaisical about it and come in and give an impassioned speech and say, I should win. And so I'm not sure in this paradigm what we do with that.
And I don't think there's a clear answer. I was listening, and I noticed that I think it'd make a difference to me if this was the initial appearance Or
Talking about a civil trial, though.
a civil trial, an eviction trial, they'd been here before, and you'd set it for a trial, and they were back, well, then I think the plaintiff, I think the person needs to have been prepared.
And a regular civil trial as well, would you
Yeah.
agree?
Okay, all right, fine.
If I'm comfortable that at the pretrial, it was clearly explained to them that they needed to bring all of their evidence.
And for those courts who don't have pretrials, should they continue that trial to allow a litigant they'll continue to let them bring the documents in next week?
It depends on the comfort level and how satisfied you are that they were aware that they needed to bring everything. I think I would look at whether or not what they're alleging would provide a valid defense.
I can give an example. This happened a couple of years ago. It was 2 cases, but they happened about 2 weeks apart. Both of them were automobile accidents. The plaintiff was suing for damages. The plaintiff moved to introduce an estimate from a body shop. The counsel for the defendant stood up and objected on the basis of hearsay. And I said, okay, counsel, did this plaintiff disclose this estimate to you as part of disclosure? He said, yes. I said, did you tell him you were going to interpose a hearsay objection if he offered it? He said, no, that's not my job. I said, you're right. It's not your job. And counsel, I'm sustaining your objection. But now I'm also giving this plaintiff a continuance to go and subpoena the author of the estimate so they can testify. Never mind, Judge, I withdraw my objection. Okay. 2 weeks later, different parties, exactly the same scenario, except counsel, did you tell this plaintiff you were going to interpose a hearsay objection? He said, yes, I did, Your Honor. Here is the letter I wrote him after I got his disclosure saying, I don't trust this estimate, it's unreliable, I will interpose a hearsay objection at trial. Plaintiff, did you get this letter? Well, yes, Judge, I got that letter, but I don't know what it's talking about. I don't understand what hearsay is. I go, oh no, sir. You cannot use ignorance as a weapon in this court. You should have found out at that point. Objection sustained.
I have one more follow-up question. I'm sorry.
No.
Years ago, I had I had 2 pro pers, and one of the litigants brought a great big grocery bag full of receipts and brought it up to the bench and said, here's my evidence, Judge. And later, many years later, someone gave me the quote about a judge is not a pig ruffling through the forest for truffles or something like that. I took that big bag of receipts. She was an elderly lady, and I organized it just to see what was there. I guess the question is, to what extent do we need to kind of organize those documents as they come in? Or how strict are you gentlemen being in terms of having the exhibits marked and things of that nature? Thank you.
I've actually told people I'm not H&R Block. I'm not going to figure this stuff out for you. When they hand me a big stack of, well, here are all my, and it's the failure to, it starts as a failure to return a security deposit case, and it becomes a counterclaim where it looks like it's basically the homeowner's remodeling the house and trying to get the prior tenant to pay for everything. And so you get this giant pile of stuff, and there's, well, my damages are in there somewhere. And I'm like, well, you're going to have to at least add them up. I'm not going to do that for you. The only situation where a judge got in trouble for crossing a line, and it's an older opinion out of a California ethics opinion. It's when they were interacting with the person in the courtroom. They gave him really good advice. They said, well, if you're going to file for a divorce, you need to do this. But they actually walked them over to the Superior Court side of the building, helped them fill out the divorce kit paperwork, and helped them file the waiver of counsel form, and then stood next to them as they filed that in Superior Court. And the California Commission on Judicial Conduct said, no, the judge is not obligated to act as counsel for the, it's like A and B are okay, C and D are way over the line. And so maybe there's not a bright line rule, but yeah, I mean, if you want to say, oh, just take a recess while I prepare your exhibits for you, then that would probably be over the line. Okay, yeah.
Okay, moving on. Step number 9 is, once again, provide a final opportunity for litigants to add to their testimony or to present additional evidence. And again, this is to ensure that people believe that they have been heard. And the final step in managing evidence, when necessary, the judge should remind the parties that the judge must be neutral and fair. So any questions about managing evidence? Okay, we have a question.
Thank you. Could you go back to slide number 9 for just a moment, because it's something I wanted to reference. Okay, fair enough. But so you've come to the plaintiff rests, the defendant rests. I understand procedurally to make sure that parties have an opportunity to be heard. You may then take this out of order and say, fine. Does either party have any additional information they want to offer, any additional evidence? Fair enough, but if you deviate from the way that a trial is actually conducted, are you not at this point then, and offering it to both parties, opening it up for the plaintiff to say, well, yeah, as a matter of fact, Judge, I do. There's something I forgot to say, so let me tell you about this and let me give you some evidence on that. Great, you're reinitiating the potential for cross-examination. My question to you is, when you talk about this as, point number 9, is it, since we're talking about closing arguments, plaintiff is rest, defense is rest, you reopen the door at this point, or do it in a more formal fashion, and that is plaintiff rest. Okay, now are you sure there's nothing further you want to offer? No further evidence, no further witnesses. This will be your last opportunity. Procedurally, how do you address it?
Well, I like your latter approach the best, but remember, Craig, there's a possibility for rebuttal. So I will say, after the defendant rests, plaintiff, this is your opportunity to present rebuttal. Now, you can't go into anything new here. Anything you're offering now is something that was covered in the defendant's case that you want to give a fairer picture to. Is there anything like that? But I think this is mostly to encourage before each party resting. Is there anything else? Have you presented everything I need here? I think that's mainly the direction.
Yeah. And if there is something that's that crucial, and you are the judge, you're the determinator, you make the determination whether or not it's important enough to possibly reopen the plaintiff's case. We want to reach the right decision for the right reasons, not because somebody forgot to mention it.
I guess my favorite comment of defendant or of self-represented litigants is, Judge, you can just call my best friend and she'll tell you that I'm correct. I assume you don't want us to call that number.
Yeah. Okay, concluding the proceeding.
Oh.
In a civil trial, non-jury, one represented litigant, one non-represented litigant, and the represented litigant has an attorney who's asking a series of questions that are going to adduce hearsay. The non-represented person doesn't know enough to object. Could you suggest some ways to manage that situation?
I had that situation, and it was one of our favorite landlord attorneys, and I just let him go ahead. And then at the end, I said, what I have is live testimony from this defendant going this way, and I have the testimony that you, counsel, got in
We have to move on.
that goes the other way. But of course, what you were introducing was hearsay evidence, and it wasn't objected to so it came in. But counsel, I can't ignore my training in the evidence. We leave out hearsay because it's not reliable. I've got a live person, and I've got the hearsay you offered. Guess who wins?
As a follow-up, would you...
We can save the follow-ups for the scenarios where we're going to be pressed to finish here. So let's move on.
Well, we can almost just say on the just. I don't know that we have that much new material on. We've already prior speakers have already talked about announcing decisions from the bench and why that's good and why that's helpful in explaining your decision if you can. I would almost rather blow through this just so we get to the scenarios, because I think really that's what.
Oh, wait, Gerald.
Well, no, I mean, it's.
No, I think you're right. Go
Yeah,
ahead.
so just, there's, when a prior JP does a whole speech on the art of judging, and one of his things is to, if you know someone's going to be mad at your decision, let them read it with their phone bill. So, like was said earlier, announce a decision, explain the decision. One of the court tools measurements is that people understand what's happening to them, and if people leave the courtroom and they maybe don't agree with the result, but they at least think they were treated fairly, or if there's something that they have to do, if they know what the next step is, then I think we have won as judges, because we're never going to make everybody happy, but at least we can make people think that they were treated fairly.
And the only qualification I would put on that is I will often take civil cases under advisement, but rarely, if ever, take an eviction case under advisement. I will explain my reasons for evictions right there, because they've got 5 days to appeal. And I'm also going to tell them that. I've made my decision. This is the reason for it. If you're going to appeal, you absolutely have the right to appeal, but if you're going to appeal, you have 5 days to do it. So, good luck.
Okay. And we wrapped up quickly. Read the rest of the best practice. We did have some procedural fairness slides there, and those tied very closely into what Chief Justice Bales mentioned this morning. We can either break now or ask a few questions, but any question you ask now is going to take away from the time from the panel of experts that we have.
And remember, the scenarios are the exciting part.
They are.
Yeah,
they are.
this is
So
as riveting as this was.
Let's break now. You get a 15-minute break. We're going to start right up at 11 o'clock with our panel. If I can have the panelists please come up. Okay, and for those who've attended our sessions before, you know the judges panel at the end is usually the most exciting portion, so we're ready to excite you. And we have Judge McMurray and Judge Williams are running around with the microphones. They've replaced Cheryl, so again, any question that you have has to be on microphone if you want to be recorded for all of history. And our panel, first, Anna Mary Glab was on the panel. She got ill, and so she sends her regrets. But we do have the Honorable Carl Epic. Most of you do know Judge Epic, formerly of the Mesa City Court. He is now the presiding family court judge in Pinal County, so we can all offer condolences on that assignment. Honorable Myra Harris, our commissioner who does handle our civil appeals, and she has been a participant on our panels before. Everyone, I believe everyone in the room knows Paul Julian. He is the Supreme Court Judicial Education Officer, and Paul has done a lot of work on self-represented litigants. I believe you were in the bathroom when I offered you that you might have more information on Richard Zorza if you wanted to work that into any of your answers. George Reamer, everyone knows, is the Executive Director of the Judicial Conduct Commission, and he has been a panelist for us before, so we thank him. Everyone knows Honorable Rachel Torres Carrillo, and she is on the, what is that committee?
See, now you're making me nervous. I don't even know what it is. Commission to Access Justice.
Okay, and the chair of that committee is the Honorable Lawrence Winthrop from the Arizona Court of Appeals. And here's the special slide. You might want to turn around. He did just win the James A. Walsh Outstanding Jurist Award from the State Bar. So. And before we go into the scenarios, the PowerPoint is not in your materials. The scenarios are. So we're going to be working from the scenarios. They do have the they have the fact patterns. They have the questions. We want lots of input from the crowd. That's why we have 2 microphones going around in the crowd. And Kim wanted me to make sure that before you leave today, you do get your parking validated. And so validation is at the back table. Any other housekeeping matters? Okay. So let's go with scenario number 1. In an eviction trial, the landlord's attorney presents a clearly defective 5-day notice. The SRL tenant does not object. A proper 5-day notice was issued, but it appears the SRL tenant, let's go to the questions before that.
And Charlie, since they're not on the slideshow and this is being recorded, I think we probably should read them. So, panel, the SRL tenant doesn't object. Should you, as the judge, raise this defect on behalf of the SRL tenant or advise the SRL tenant about how to do so? How do you do so without crossing any lines?
All right. Judge Carrillo, you going to respond?
Okay, I will. Yes, I think you should. First, like we do all the time, we go over the 5-day notice. Now, it says eviction trial, so hopefully they would have done that prior to that time. If there was something wrong, you would have known at that time. But if it wasn't raised at that time, I think it's still important to raise it, that this, that it was clearly defective. What was wrong with it? Did they even get it? Did they get the 5-day notice? Were they served? Were they aware of it? All this information needs to be presented as well to the defendant or the self-represented litigant. As far as how do we not cross the lines, I think we have to raise this issue because it is an issue. If we see that it was not properly served or something was wrong with it, we do need to let everybody know, including the self-represented litigant, that it's invalid.
Let's flesh out this clearly defective notice. How about a 5-day notice that doesn't have any amounts on it at all? You haven't paid your rent. You could pay it in 5 days or you're out.
Right.
Would you raise that?
I would raise that question because they have a right to know you're here, why you're here, because you haven't paid rent, how much is it? Maybe the person would have paid within those 5 days.
I mean, I think that I'm sorry, that the idea is that the notices have to be curable. And so anything that's defective, you're not giving them the opportunity to cure. And so I don't think that we can procedurally go forward with something that from the base is not valid.
I just want to follow up on that same comment. I have often asked an SRL landlord, what do you think the reason for this 5-day notice is? It's not just a technicality that you have to do it. It's to give the tenant the opportunity to cure, to give them an opportunity to fix the problem before coming to court. So I've seen a lot of these notices that just say you haven't paid the rent, you have to be out in 5 days. I said that notice doesn't give anybody an opportunity to cure anything. The notice must state what they need to do to fix the problem. If it doesn't, it's a defective notice at that point.
Paul?
Well, thank you. And again, thanks for putting this together. The question itself says, should you raise this defect on behalf of the SRL? That's a little bit different than what we're answering at this point. And then the next one is, should or advise the SRL tenant. I mean, that raising on behalf and advising, those are key words that start making it sound like you're being someone other than a neutral judicial officer, but rather an advocate. And so I think maybe then the reason that the second question is, how do you do so without crossing any lines? Well, you don't do it on behalf of, or you don't do it advising. You do it as a judicial officer, stating what the law is, what the elements are, and what's required, rather than acting as though you're being someone, siding with the self-represented litigant.
Okay, so let's go to the next part of the scenario. We have a proper 5-day notice, but now you're starting to suspect that the tenant may have a defense or counterclaim based upon an issue of habitability, and the tenant is not acting or appears to be aware that she may have a defense or a counterclaim. Do you raise this now in the trial? I think it's a different question.
Oh, yeah.
You know, I think we got a preview of this from our earlier speakers, and that is perfectly acceptable to ask the tenant why they didn't pay the rent, whether they owe it, whether they understand that, but why didn't they pay? And recognize, of course, that the landlord, who's either there by themselves or through counsel, can cross-examine the tenant on the information they're giving in response to the judge's question.
I think part of this comes down to the way the question is phrased when it says might have and possible, though, because it's not up to the court to determine possibilities that somebody could raise. It's at that point, you may be crossing the line in providing legal advice. That's different from saying, why did you not do this? But if you're then saying, well, I can come up with a counterclaim for you, and I'm going to tell you about it, now I think you've crossed the line, and I think that the represented landlord's attorney is going to be filing a judicial complaint against you and saying, wait a second, once it comes to doing shoulds, and that's one of the key words I tend to focus on. When you're saying what you should do, you're giving legal advice. When you're saying what happened, what else happened, then you're asking questions or providing and getting information. So it's the should word that I really have a problem with here, because the way the question is phrased, it's not specific. There is the possibility that. And I don't think as a judicial officer we're supposed to be looking at what possible claims could each party possibly raise.
I wrote this as quicksand. I think most of you know that before the 13 years that I have worked for the Supreme Court, I was the director of Southern Arizona Legal Aid. And you know, I certainly agree with what's been said, but you know, we don't have a civil equivalent of Gideon. We don't provide lawyers for people generally in civil cases unless there might be some extraordinary circumstances. But you know, we find them guilty in these eviction cases, if you will, and we use that term. And if anything comes close to that type of a situation, and if you have even a sense that there might be a defense, I just propose this. Would it be appropriate to say, you know what, you might want to get a lawyer. You know, you have a right to an attorney in this case, if you want to have one before we proceed, and it might be helpful to you. I don't know. I mean, it makes me very nervous doing that, but on the other hand, you know, I think this goes on and people are not given a full opportunity to defend themselves because they don't know the law. It's complicated. And, you know, I mean, this started off with the landlord not fulfilling the statutory requirement on the 5-day notice. I'd appreciate thoughts from the rest of you about that, because I realize I'm a little tainted.
You have a question here.
With regard to the 5-day notice, where we see it's improper, and now we're dealing with a situation where the defendant hasn't shown up, the defendant's defaulted. Are we applying the same scrutiny you've described? So the 5-day notice you know is deficient, it was filed improperly, maybe they're doing an immediate when it should be a 10-day. Do you need to now apply the same scrutiny and then say, hold on, this is deficient, and dismiss?
Well, actually, I wasn't referring to the 5-day notice. I was referring to the potential of a legitimate defense that's not going to get raised.
I apologize. I've gone back to the first.
Yeah, no, that's fine.
You know, what I would say to that is that the landlord has the burden of proof, and part of that proof is showing statutory compliance. And so the fact that the defendant has not shown up, at least in my view, doesn't answer the question. Has the landlord met that burden of proof? It's almost similar to a jurisdictional question the court has to ask itself. Do I have jurisdiction over this matter? So I think it's perfectly appropriate if you see a defective notice on its face and you then question the landlord about it and to send them back to do it the right way.
Let's move on to scenario number 2, and this is an order of protection hearing. And in this case, the petitioner is self-represented and actually has a pending criminal charge against him for the same incident, but he has the, let's say, chutzpah to come in and ask for an order of protection against the victim. So the questions are, do you inform the petitioner of the right to remain silent? How strenuously? Do you tell him if he chooses to testify, he'll be subject to cross-examination? What if the defendant has an attorney? Does this change how you proceed? We'd like to address that.
My short answer is yes. Anytime somebody's going to testify in an order of protection or any civil hearing, and I think that their potential for exposure to criminal prosecution, I don't think there's anything wrong with you. And in fact, I think it's probably incumbent on you in most circumstances to inform them they have a right to remain silent. The way I usually phrase it is something along the lines of, I understand there may be a criminal case pending. You should be aware if you choose to testify in these proceedings. Anything you say is being recorded. It's possible that that could be used against you in a later proceeding. You don't have to testify if you don't want to. If you do testify, they'll be able to ask you questions, and you will be required to answer those. On the other hand, you can remain silent. Now, in order of protection context, you don't want to add the, you can remain silent and that won't be held against you, because actually the judge is allowed to infer from silence to draw the negative inference. Moreover, if this is the only person testifying and he's the petitioner, and that's the only evidence he's got is his own testimony, if he invokes his right to testify, then I don't think you have any basis to issue the order because there's no evidence to support it. But I think regardless of which of these parties is, if you think there's potential exposure there that you're not only should you, but I think you're obligated to do that. I don't think there's any ethical issues there. And I don't think it makes any difference if the person you're advising, is unrepresented. I think you need to do it. And it says here the defendant having an attorney, if the person who potentially is facing the exposure has counsel, I typically don't advise them because I presume that counsel has, or it's certainly the responsibility of counsel to advise them as to the potential consequences of them taking the stand.
So, Judge Eppich, I can get you telling the petitioner, who is a criminal defendant elsewhere, that warning him about taking the stand and the consequences, but as part of that warning that says, okay, now also recognize that in this hearing, if you don't testify, you're not going to get this order. Are you going to tell them that?
I don't know if I'd phrase it that way, but I think it's fair to say that, you know, in that context, you could tell them that if they're unable to present any evidence, that they won't get the order. I don't know that there's a problem with that. I wouldn't say right out off the bat you won't get the order, because there's always that possibility that they could get it some other way. And I think we get to other questions here that relate to that.
Exactly. So the response is, well, I'm going to get that way by questioning the victim. So the SRL petitioner wants to call the SRL defendant as a witness. She is a victim in the pending DV criminal case. Do you inform the victim of her right, of her victim's rights not to be questioned as a victim, and how strenuously?
All right, and this is one where I hear the voice of my torts professor from law school telling me not to fight the hypothetical. But frankly, there is not a victim's right not to testify in a legal proceeding. The victim's right is to not be subject to a pretrial interview by the defendant or counsel, or subject to a deposition or discovery requests. So I think the person has the right to call the victim, the alleged victim, as a witness, and to question the victim. You do have the ability, though, and the obligation to make sure that that the questioning of the victim isn't abusive. And I think you also can limit the questioning in such a way when it becomes clear, if it becomes clear, that this is really a backdoor effort at some type of discovery, rather than about whether or not there should be an order of protection.
Okay, I would concur with that. Also, even if it were not, the Victim's Bill of Rights talks about discovery issues. It doesn't talk about testifying at trials, and in all kinds of criminal cases, victims testify at trials because they testify about what happened. If you had to weigh and balance the victim's rights against the right against cross-examination, I think the due process part of cross-examination, because orders of protection are civil, not criminal, would outweigh the victim's rights. I think they would trump it, because your due process rights come from both the federal and the state constitutions. The victim's rights is in our state constitution, but I think the due process of being able to cross-examine the party against you would probably trump that. So I thought I'd just throw that in.
And if you think about the rationale behind the victim's rights, it's to prevent the victim from being abused. And in the context of a court proceeding, that's your job. So that protection is there in terms of your ability to limit the questioning, to make sure the victim's not being badgered, anything like that. You also need to keep in mind that with these domestic violence situations, you're going to get somebody who's the defendant and somebody who's the victim. And for all you know, the police in their charging decision got it wrong. They may both be potentially defendants. They may both actually be victims, maybe one, maybe the other. You don't necessarily know that. So I think you have to sort of play it straight and not presume that the person who's accused, who's presumed to be innocent, is in fact the bad guy in this.
Just a practice point, and it doesn't say in the scenario whether or not this is the hearing for the first opportunity for the order, or if there was an ex parte request. What I try to do, of course, without dissuading someone from pursuing a request, at that opportunity, explain the unusual format of an ex parte contact between anyone and a judge, and explain, if you request this and it's granted, if I grant this order, there's a possibility there's going to be hearing. And so these issues, if you have that opportunity, can be sort of vetted at that point in time. Again, not with the intent of dissuading someone from pursuing it, but at least make them aware that you may end up, you're going to have to testify, or at least provide some evidence to the court in order to maintain this. And so if you go through that at the time of the ex parte hearing, you might be able to avoid some of this.
Okay, moving on. After the presentation of all the evidence, you do find that an order of protection is appropriate. The SRL defendant is confused and angry because the petitioner has pending criminal charges. The defendant further complains because they have a child in common. This is the first you've heard about that. And wants to know how are they going to make child care arrangements. So the questions are, how well do you explain the decision to her? Does your statement resolve issues with compliance for the parties? Do you have any obligation to set expectations for the petitioner's or defendant's next steps?
I would say that, first of all, you have to explain your ruling, because the Arizona Rules of Protective Order Proceedings require you to do so in Rule 8. You have to give the reasons for your rulings. So I can understand the defendant being confused, and you need to explain that they're two different proceedings, that the order of protection, which has now been granted for the petitioner criminal defendant, is a keep-away order that says she needs to keep away from him. And that's being granted because he proved his case by the preponderance of the evidence, and remind her that at the beginning of the hearing, that which you theoretically did, you explained what the burden of proof was for the petitioner, and you also explained the other rules that would be going into the hearing. Once she knows that, and now she brings up, well, we have a child in common, that you need to explain to her that issues about child access, parenting, are issues that are going to be handled in a family court proceeding, not in an order of protection proceeding. And so while they may have issues about what to do and how to do it, this is not going to be raised or handled here today, because that's not the focus of the hearing. The focus of your order of protection hearing is simply to provide protection for the party who needs it. And I would probably tell both litigants, if she feels she needs protection, she's certainly entitled to also seek her own order of protection, by going down, well, at Superior Court, it's going down to the Family Violence Protective Service Center or filling out the appropriate petition and bringing it up to court. She has the same rights to get a protective order, but the protective orders don't concern parenting decisions. Those are left to the family court in a family court proceeding.
So, Judge Harris, I get that you've got to refer family issues to family court, but what about this business of, would you consider looking back at your no contact order to modify it some way about contacting with regard to child care arrangements? Because nobody has accused so far anybody of hurting or posing a threat to the child.
Nobody's accused of posing a threat to the child, but the parties, if they have a true no contact order between the two of them, can find alternate ways without changing my order. Dad can elect to say, grandma, grandpa, next door neighbor, aunt, uncle, whoever, will contact whoever mother's representative is, or mother. Mother can contact father's representative. They can work out a way to do it without contacting each other. In many cases, I was on the family court bench for 10 years. So one of the huge reasons for having domestic violence issues is because they can't get along about what's happening with the child. And so saying, well, yes, you can talk to each other to work out what's happening with the child is almost like lighting a little fire that can then become a conflagration. So if we determined in the order of protection hearing that the parties shouldn't be having contact because it poses a danger to petitioner, I don't think I'd change the order to say, yes, you can do it. I'd tell them that they need to find alternate people to make arrangements with, or on behalf of how the child will be exchanged, and refer them to family court, where they can file a petition for, temporary parenting time orders, if necessary, or if that's what they need and they haven't gone to family court at all. Because they have a child in common, unless this is prior to any kind of dissolution or paternity proceeding, they probably have a family court case pending. If it's the first one, then they need to go to family court and let the family court handle what family court's supposed to do.
I would have a slightly different answer. I don't think there's anything wrong with your sort of reopening it once you get this new information to the issue of whether or not you should make some exceptions for contact, whether it be by phone or by third party. I think what the judge has proposed in terms of grandma or whatever, I think you need to then put in a third party exception, because
otherwise it's indirectly contact.
It's a violation of the order, I think. And keep in mind, it's true, you cannot issue child custody orders out of limited jurisdiction courts. But you can certainly craft your order of protection in a way, provided that it still protects the party. I mean, there are times when no contact is what you got to have, even if there's kids. I will grant you that. But generally speaking, in a scenario where, why can't a third party do it, or maybe as email or text, there are cases where the exceptions are appropriate, and there's nothing wrong with putting exceptions in to facilitate, as long as the children are protected parties, you have concerns about the safety of the children. Because once you say, well, I'm not going to address it, I've already decided no contact, go to family court, then you may be putting into play a process that the parties don't really want. Typically, if somebody's going to be filing for a temporary order, the way the rules read, the temporary order is to be filed either subsequent to or simultaneous with a petition for dissolution, a petition for legal decision-making between, if they're not married parents, with permanent orders and permanent consequences. In this incident, as we all know, and like it or not, may be something that is just a blip on their sort of life, and they're going to be all back together and everything is going to be hunky-dory without the need for them to access family court. So that would be my suggestion is, in the appropriate circumstances, absolutely no contact is fine, but there's nothing wrong with crafting exceptions if you think that those exceptions are still sufficient to allow for the needed protection.
Okay, is scenario number 3, Judge McMurray, do you want to take this one?
Well, this was one I forgot it was a scenario. Plaintiff and represented defendant. The plaintiff presents an automobile repair estimate that he disclosed in discovery. The defendant's attorney objects as hearsay. Panel, what further inquiry, if any, should you make as to the disclosure? Plaintiff has otherwise proved his prima facie case. How do you proceed?
Apparently nobody wants to answer this
Yeah,
question.
well, I feel like I'm humbled by even being on this panel. But one of the things that I wondered about was whether or not there'd been any objection to the disclosure in the first place, before the trial. I mean, that's not necessarily something that happens in cases that we see as justices of the peace. But I suppose that maybe you could give an opportunity for I mean, you don't want to, I don't think it's appropriate for you to get into the hearsay rules as far as explaining, what the rights of the plaintiff are in order to prove that there is some, I mean, we've got more exceptions to the rule on hearsay than we have in the rule, and, there are many of them. But again, this makes me nervous getting into this, and I would assume that your represented defendant is objecting here already and not going to let you do very much without objecting further. So you might give more time depending on how long this thing has been carried out, and you've got the prima facie case already met. Otherwise, so does it really make any difference? I don't think so.
Well, this one strikes me as being very similar to what our previous panel presented, where they had the repair estimate disclosed during disclosure, and then it was, did the attorney let the plaintiff know about the objection the hearsay objection prior to trial, and what they would do about it. And so I think at that point, you could probably do one of two things. You could say, well, I'm going to admit it and give it the weight I think it's worth. Or you could simply sit there and say, yes, I'm going to not admit it as hearsay, or you could ask some foundational questions on your own to the plaintiff to find out if this estimate is reliable. Who is the estimate from? What kind of repair place? Is the person writing the estimate the plaintiff's best friend who does car repair on the side? Or is it, a major business? So I'd be looking at exactly what is this estimate as well in terms of how reliable is the estimate likely to be. Is this being done for an insurance company for insurance purposes? Who prepared this estimate? What company, where, how, when, for what purpose? Was it prepared just for litigation? I mean, those are questions I would want answers to before I would admit it.
So, Judge, what would you do if you're getting continued objections from the attorney about your questioning? Would you just go ahead and continue with the questioning, or that makes me nervous? If assuming the attorney's going to object to you asking these questions.
I'd ask the attorney for the basis for the objection, other than just saying hearsay. I'd want to know a specific basis. Because, again, not all hearsay is objectionable. So the question becomes to me, is this hearsay going to fit within any of the exceptions? Let the attorney tell me it's not.
I think also you may have a little more leeway to do some questioning with respect to this type of an objection, a hearsay objection, because a lot of times it's not as much a hearsay objection as it's a foundational objection, and I think you're allowed to explore those a little more with the parties, just because controlling the admission of evidence is what you do, and yes, they're going to make the objections, you're going to rule on the objection that's put before you. But as long as you're not putting your thumb on the scale and you're indicating why it is, or you're clarifying, or that sort of thing, I don't see a problem with you asking questions to get at the meat of what the objection is and what the response is. And then if you're going to let something in and it's a judgment call, there's nothing that prohibits you from saying, and I'm overruling the objection, but the objection raised certainly goes to the weight of the evidence, and I'll take that into account. And that way, at least somebody's satisfied they got, that what you're doing, and that maybe they're going to get some benefit from it regardless.
Well, I think our panel is foreshadowing the next question, and that has to do with the self-represented plaintiff attempts to offer a picture printed from his home computer, and the defendant's attorney objects on the basis of foundation and on relevancy. And the question is, may you ask questions of the plaintiff to defeat the objection?
Yes.
Well, yeah, I think we.
How about to sustain the objection?
I think we had that explored in the earlier panel, and I personally see nothing wrong with the judge asking clarifying questions to determine whether there's a basis upon which to admit the evidence.
But again, and just on the wording of the question is, may you ask questions of the plaintiff to defeat the objection? If that's your goal, that's probably not appropriate. But I think that's a good point, though. I mean, you have to be careful not to get right into the middle of the litigation and start feeling like you're advocating for one side or the other. And I think there is a tendency, this is just not clear cut. And in a way, it's sort of evolving, at least during the 30 years I've been practicing. I think there's more and more tolerance for this sort of thing, with the rules that we have that George is responsible for, and maybe you could speak to that just kind of generally. But, I remember when I first started practicing, before maybe some of you were even born, there was just a different approach to this and somewhat callous.
Great opportunity for a segue here. And I was going to jump in anyway, because I know that in the back of your mind is the question, when could this become unethical? And that's the fear the judges have, that somebody's going to complain that said you weighed in on behalf of someone, you showed you were partial, you were biased in favor of a party or prejudiced against me. And that isn't probably always very easy to determine. The rule, at least one principal rule, says you shall perform all duties of judicial office fairly and impartially. So then you go back to the definition, and there is a definition of impartiality. Impartial means absence of bias or prejudice in favor of or against particular parties or classes of parties, as well as the maintenance of an open mind in considering questions that come before you. In the prior presentation, I was thinking to myself, I think you handle a lot more cases than we have complaints.
Thank goodness.
And so I think that is really good news, because people do bring this issue up, that the judge was biased in favor of the police officer, or, there are a lot of different scenarios. But you have to really drill down and determine, was it unethical? And I think that's a whole different standard. Now, you can argue, well, fair, impartial, those are terms kind of, different interpretations. But these are rules of reason, and the rules of reason are interpreted by what I consider to be a reasonable group. Judge Winthrop, being a reasonable judge, was a member of the commission for many years. It's a well-crafted structure where you have representatives from the Court of Appeals, Superior Court, Justice Court, Municipal Court, public, and those reasonable people are evaluating these questions as to whether or not what you did was unethical. The appellate process is there for dealing with all of the other issues. So that's in the back of your mind. And I think you do need to keep that in the back of your mind, as to wonder when is your interaction gone to the point of being truly unethically partial, but I don't think you need to be intimidated by that. And I think the whole development of these the rules and guidelines and scripts are great, because we all know how many people are not able to afford lawyers. And it's only going to become, I think, more prevalent rather than less. So I don't think you need to be overly concerned that just because somebody complains that it's going to have really any merit as a matter of ethics.
I don't think there's any problem with phrasing a request for the non-objecting party to respond in a way that clarifies what the objection is. I mean, here you have the attorneys say, objection, relevance, lack of foundation. I don't think there's anything wrong with turning to the unrepresented party and saying, how is it that this makes a difference as to whether or not A, B, or C? In other words, you've just paraphrased what the term relevance means in asking them to respond to the objection. I think that's perfectly acceptable. And with the foundation, obviously, the rule provides you can ask the objecting party what's lacking. Well, if the responding party can ask that, I don't think there's anything wrong with the court asking it. And frankly, I'd say at least 50% of the time I've had an attorney object based on foundation, I have no idea why they think the foundation's lacking. So if I can't figure it out, I wouldn't expect anybody else to figure it out either. So I think it's perfectly okay for me to ask.
There's another consideration, and I agree with Carl, and that is, and it's what we heard a lot of this morning, in this concept of you can't give legal advice, but you can certainly share legal information with the self-represented litigant. And to follow up on what George was saying, as a member of the commission for several years, I think this is true, and he can correct me if I'm wrong, but we never disciplined a judge for giving too much legal information to a self-represented litigant. So as far as I'm concerned, you can err on that side. It's a matter of perception, how you phrase what you say to the parties, and if you do it in the guise or the form of here's what one side needs, or here's what you need to prove for each part of your case, you're simply educating them and giving them legal information. You're not telling them how to do it.
And I might add I mean, Rule 614 we'll talk about, I think, at a later scenario, but it does give you the right to ask questions. But anytime I intervene, I don't do it as, now taking over the case, but rather always give the opposing party or opposing party's counsel an opportunity to follow up with questions after I've asked questions. I don't stop there and say, okay, this is where we're going to move forward. And that at least gives the perception, again, of giving another opportunity.
What I wanted to add is I think everybody has had this happen to us one time or another, maybe several times. And my question is, what happens if you don't intervene in any way with this case? I think you should ask yourself what's going to happen. And exactly the part about questioning, I don't know if you're wanting to defeat the objection. The mindset has to be now is that how are we going to help in some way to help the litigant understand what they're actually asking and to participate with that, because maybe we'll get the answer that way. But I think disturbs me a lot is that this happens a lot and we didn't ask any other questions. So what happened to the case?
Well, if I may, if I can ask you a question in this regard, obviously very scenario-based, but that is any thoughts about, of course, it going over the line with the questioning from the judge, and I understand there's a role for the judge to play in asking these questions, but if you have, for example, a plaintiff's case that you think is perhaps marginal at best as far as them having actually met their burden of proof, and you turn to the defendant and you tell them, now, as you might remember from when we began these proceedings, I told you, you don't have to testify, It's not that it's your right to not testify, it's just you don't have to say anything if you don't want to, but understand, sir, if you don't, I'll make my decision having heard from one party, and while you may feel they haven't met their burden of proof, I may not share that opinion. So if you want to say something, now is the opportunity to do it. Okay, fine, you've opened the door, and now maybe you get something from the defendant in the way of, and they'll typically clam up, but you might get something that's really not too terribly helpful, such as, and it's a civil case, of course, well, Judge, I just didn't do it. Well, that really hasn't produced much that's helpful. So you might go the extra step to say, well, sir, now what exactly do you mean by you didn't do it? Now you get something that is actually more enlightening. They actually decide to expand upon it, and they'd say, well, I meant I didn't do it. I didn't do exactly what he said, but I did do this. And now you have an admission that might actually speak to the plaintiff's case here. The plaintiff probably, in your opinion, hadn't really met much of a case, but now you've got essentially an admission from the defendant, well, I did indeed do that. All I'm trying to say is, yeah, sure, this is very specific, but does it cause you any concern at some point in time of saying, yeah, you know, even if you're not doing anything that actually could be, that could compel testimony and somebody to admit to something, you can take this too far where somebody's going to say, oh, geez, there's a man or a woman in a black robe up there and they're asking me questions. I guess I need to start asking, or I need to start providing some answers.
Why don't we move on to scenario number 4? And so this is an unrepresented petitioner and defendant at a harassment injunction hearing, which somehow has reached you with only one alleged act of harassment. During testimony, plaintiff alleges a clearly supportive act that was not in the petition, and the defendant does not object. Should you ask the defendant if she objects? If the defendant objects, do you proceed? What are the advantages of allowing exploration of such issues? What kind of information about the right not to have issues expanded should litigants be given? What kind of waiver of rights should be required before the case goes beyond the scope of the hearing?
Okay, good. Did you? No, go ahead. Okay. To start with, the original IAH is defective. And I don't think, as a judge, you can simply say, well, we're going to ignore the fact that it's defective. I don't think you can allow the plaintiff to introduce new allegations at a contested hearing. It violates due process. The defendant has a right to know what charges the defendant was supposed to be facing and to prepare for those. And to then say, well, we'll let the plaintiff introduce something else allows the element of surprise in without giving defendant any notice. So I think you can't do that. I think you can tell the plaintiff petitioner, plaintiff in this case, that the original petition is insufficient for an injunction against harassment because there need to be 2 acts. And people can go down and file new petitions. But the defendant has a right to be apprised of those. And I don't think you can simply rule on the original one and allow an in-court amendment without violating due process.
Aren't there a lot of, isn't there a lot of background information already available in a lot of these areas as to what are the elements of a particular petition to prove the case? So there's a lot of good legal information, and that is disseminated widely, I think. And so if you get into just explaining, well, these are the things that need to be established, I don't see anything particularly wrong with that. It's just general legal information. But I mean, you can't help a plaintiff prove their case. So I think the more information that is available on the internet and by pamphlets, by self-service centers, I think that would be a point of attack here.
Can we back this question up to the initial appearance? And quite often I've seen petitions for these IHs that are missing the second harassment incident. Is it appropriate at that point in time in the initial ex parte hearing to question the petitioner about, are there any other incidences? I cannot issue this on a single incident.
Well, but I guess my point was that for them to have the petition, wasn't there some background information that was provided, an information pamphlet that explains the elements? I would assume so. No?
No, in an ideal world, yes, but the practical reality of it is, they may print it off the internet, they come in, they hand it to the clerk stamps it, it comes upstairs. Yeah.
So how do you handle that?
I can tell you, I used to do that all the time. I don't think there was anything wrong with saying, and I usually try to do it in such a way that I'm not sort of coaching them or coaxing them, or, I kind of ask it as just an open-ended question without reference to the legal standard. So if there's just one thing alleged, I'll ask them about what happened and what that was, and I'll say, well, was there anything else? Did the person do anything, anything at all? And if they go, oh yeah, there was that time he, came after me with the butcher knife, but, what's that compared to this yelling at me? And I'll go, okay, well, and then I'll explain them what the legal standard is, and I'd have them, I'll say, because I'm inclined to issue this based on those two incidents, you're going to need to put it in the petition, and they'll put it in the petition. The key here is to make sure the copy of the petition that goes to the defendant is the amended copy of the petition. We had an issue with that when we went paperless in Mesa, where the one they'd modify in the courtroom was going out to the defendant, and that caused some notice problems. So I think it's okay to do it that way. If they just say, oh no, absolutely nothing ever happened, and I'd say, well, I'm sorry, because there has to be a series of harassing acts, and then they say, oh, but there's this other thing. If I didn't believe them, if I thought they were just making it up because now they know they're not getting one, I'm sorry. I'd say, I'm sorry, you were not alleging that. You just swore to me under oath that there was one incident. Based on the one incident, I'm not granting it. I think you can do that. But unless I really, really am persuaded that they're not being truthful about it, they're under oath. I'm not an investigator. I'm going to have to kind of presume what they're telling me is the truth, and I'd let them put it in, because I don't know that it makes much sense to say, no, I'm not going to grant you this one. They go downstairs, they pull a new file, they pay a new filing fee, it's got the very next case number on it, and then you're going to sign it.
I guess I'm a little conflicted about this, because the purpose for us being here is because we want to make it easier on people who don't represent themselves. And so I've always been mystified. I mean, I'm not on the appellate court, so it wasn't my call. I'm very mystified about this whole thing about, well, the petition has to say that there are two incidents, or else, even though we have a contested hearing and the defendant's there, the defendant doesn't object to the imperfection in the petition. The defendant, in fact, never denies the allegation of the second incident, where we're going to say, oh, sorry, case dismissed, you didn't do the petition right, because, well, let's assume that they had a good faith basis for coming into the court that day to get the court's protection against a person who is, committing a series of acts that would lead a reasonable person to be seriously alarmed. And for whatever reason, they only wrote one down. And maybe the one they wrote down could be interpreted as a course of conduct or series of acts that, maybe it adds up to 1.5 and not 2. Me, I'm going to probably, I got to be honest, if I hear 2 acts and there's no objection, I'm going to sustain the order and have the defendant sign his right to appeal and explain to him that he can do that, or she, and let the chips fall where they may.
Well, I am on the appellate court, and and what I've got to say is that, we're not on the firing line like you all are, and having to deal with these situations on the fly. And so I appreciate the fact that it's very difficult. The particular case that is referenced in the scenario, if I remember that one correctly, involved a situation where at the time of this contested hearing, I think it was the wife came in and not only had additional instances of conduct that she wanted to verbally raise, but she also wanted to expand the nature of the order of protection to include the child. And so as a matter of due process and notice, what I think the appellate court was saying is, look, what you need to do is, number one, yes, the petitioner can amend her petition, but you need to give the defendant the opportunity to not only understand what those charges are, but to prepare to address them in a subsequent hearing. And I think that's what the Savard case was all about.
Wouldn't the situation need to be analyzed as an abuse of discretion, as kind of a legal proposition? As to ethics, you know, you're supposed to follow the law. And if the law requires to, and you are ignoring the law intentionally, I mean, I think that could lead you to a claim of unethical conduct, knowing disregard of the law, as opposed to an abuse of discretion as to whether or not you did feel legitimately that there were two instances, that sort of thing. So it can get a little tricky. But I mean, I think the whole exercise here is that, you know, you're administering justice, but you can't make the party's case for them. And it isn't very easy, as many of these scenarios indicate.
Well, one of the things that Judge Harris said, I may have slipped by here, but you know, there's no res judicata or collateral estoppel on this. And as she said, you know, there's no limit. You can come back, and you know, the last question is, what do you do? And before that, it says, you're truly concerned the defendant poses a threat to the plaintiff. You know, it would seem to me that telling the petitioner, you know, you're not going to get this one, but you have a right to submit an application or petition for another. Also, just for your information, there was a major change in the Arizona Rules of Protective Order procedure at the Supreme Court's Rules Committee meeting in August, and that's you should take a look at it. They'll become effective on January 1st of 2016, but it's, I think, an overall easier flow. The rules don't have numbers of subparts like they used to, but they're separated out. I think they did it. I think Sidvik did a nice job with it. Of course, so did the Supreme Court.
I just want to add to, I think it makes more sense that when you're doing a order of harassment that from the beginning you would hate for them to come back and then find out that it's going to be dismissed because you don't have two incidents that happen. So I think that's what we're talking about today, is to take the time out to find out if there is two incidents, keep on talking to them, because for the most part, sometimes they can't think of things to say. They forget. They're afraid. They're coming into the court for the first time, getting a harassment. They don't know what's supposed to happen. Our forms say what they should be putting on there, but you know, there's a lot of people that don't read and they don't write. So somebody helps them and helps them come in, and they just say, go ahead and put that. That's one thing. But many times it's happened to me where they had several incidents because I had to ask them and you have to pull things from people sometimes. And I was able to get the information that they needed. But I have never given a harassment if it's only one time. We have to explain to them. Now, it has been one time or several times that they only put one thing on there, and I had them go back and redo it because there were 2 or 3 incidents that happened. Then at least we know the order was given. But for us not to take out the time and ask those right questions so they can, they have the answers. If they don't, well, you're not going to give it. And it's just, our obligation is to take time to listen and to try to get some of that information.
Judge Lusk has a question.
I'm not sure it's a question, but when you look at the facts, the way they're set out in the scenario, the ball got dropped somehow, pretty clearly. So the first thing you do is look down and say, did I do this? Oh, no, it was some pro tem with initial CA. Okay. Or if you're in a consolidated court, no, it was character down the hall, dropped the ball. But usually the way these things play out, when you're listening to a series of facts to justify the harassment order in the first place, the person, writes it out, and then you listen to what they have to say. Now, when they write out what looks like a single act, but when they describe it, well, the single act was about 2 hours long, and it really was kind of a series. That's a possibility. The other possibility is there was only one act in the petition, and then the petitioner then asked or brought to your attention a totally separate act on another occasion that's not a continuous course of conduct, if you will. I think the easiest solution at that point in time, and of course we're going back now, is say, all right, I'm going to ask you to write in hand, that new act and then put your initials after it. So that would have eliminated the problem from the get-go. Okay, now we're in this hearing, and I realized for the first time that I dropped the ball or somebody dropped the ball, and there was only one act alleged, and now they've given us a second good, valid act. I don't see anything wrong with asking the defendant, do you object? And he or she says, well, yes, I do. This changes everything. I wasn't prepared to defend against that. Then you've got to do what you've got to do because the ball was dropped and you didn't catch it in time. There's another alternative. I'll give you a little time. If we can amend this if you don't object, if you're really not surprised by this, then we can go forward. Or if you want to come back, we can, do another order. But you want to let them know that this doesn't mean you win. This just means that it's put off for another day. And if that's what you want to do, it's fine.
The only other thing I'd add to that, and that was good, is that the case that's referenced in the scenario, and I should have known this since I was on the panel, had to do with an allegation by mom directed at the husband that the husband had knowledge of the fact that a child's stepbrother was supposedly sexually abusing the child. And of course, under the law, orders of protection, unless there's evidence that the husband was personally intimidating or harassing the wife, she's not entitled to an order of protection against him. But she came into the hearing and then made new allegations against the husband that he was in fact intimidating and harassing, and that it implicated the whole positive Brady indicator firearm issue. And so the appellate court said, under this scenario, the father was entitled to notice of these allegations that would trigger his right to defend this, and therefore it was error for the trial court to proceed and grant the order of protection.
And I think that kind of ties into the second part of the question where, you're really concerned, though, that there's a real threat here. There's only one act alleged, but you think there's a potential for danger here and there's a threat and that sort of thing. So your instinct, just as, a human being, is I want to do what I can to make sure that people are protected. If the law doesn't allow you to do that in this context, then you can't do it. You can't fix every problem just because you've got a black robe on. There's nothing wrong with you saying in a certain circumstance, such as that one, well then, ma'am, maybe what you should do is you might want to make a report to the Department of Child Safety. You may want to pursue some type of proceeding through juvenile court, i.e. a dependency, one of those kinds of things. There are other alternatives to issuing that particular order that they're asking you to issue. And there's nothing wrong with apprising them of without giving them legal advice or telling them they should do it. You can let them know that there are other resources or other avenues to pursue relief. I don't think there's anything unethical about that. George, would you agree?
Well, I'd be interested in Commissioner Harris's prior comment about due process. I think you'd have a concern about the due process rights of the defendant, would you not?
I have a couple of concerns. First, One is we seem to be confusing the orders of protection with the injunctions against harassment. Because in the IAHs, which is what this scenario was, we don't have issues about the parties' children in the same marital relationship or familial relationship that you find. So typically your IAH cases are between two not related parties, like next door neighbors or whatever. If you have that same concern, that concern can be alleviated simply by having plaintiff go down, fill out a new IAH petition alleging 2 acts, and having defendant served. You could even state there and see if, defendant's amenable to getting served in the courtroom, perhaps, or not. I tend to not like to do that because I think that when the judge interferes that way, and then or asks the defendant, do you waive your rights? There's almost an element of coercion, particularly for unrepresented defendants who have no more knowledge than the unrepresented plaintiffs necessarily. And so when somebody with the black robe sitting up there says, you don't object, do you? Me, in my role of defendant who's never been in court before, is going, oh, no, I don't object. Anything you say, Judge, sure, because I'm afraid to say anything else. And so I would feel an element of coercion. That's why I would say, tell the parties, plaintiff, you didn't meet it. You need to have 2 elements by law. You need to have 2 acts by law. If you have 2 acts, you go down, you fill out a new petition, you come up, you have an ex parte hearing, and you get the guy or the lady or whoever it is served a second time. And then, defendant, once you've been served, you can ask for a new hearing. Okay? We'll set a new hearing for you. You have the right to have counsel if you want them. But I think the defendant has a right to know these things and not get surprised. Because maybe with the second allegation, they would have said, oh, this is a lot more serious. This could affect my job. This could affect my...
I think that's a signal to move on.
Okay, let's move to scenario number 5. At an eviction initial appearance, both the landlord and tenant are unrepresented, and both are woefully unprepared. While discussing the matter with the court, the landlord discloses the 5-day notice, which you note is also in the file, and the tenant admits she's not paid rent for 2 months. The landlord will not accept judgment for only the 2 months' rent because the landlord also wants some HOA fines included in the judgment. The landlord, however, does not have a copy of her lease with her today. Do you proceed to trial today? Are there other alternatives? Do you explain the other alternatives? How strenuously?
We're all looking at you, Judge.
All right, I'll try anyway. All right, what the most important, of course, is does the complaint have that she wants HOA fees? But the most important is to have the lease and in front of you saying that, I'm confused about the fact that they would be paying HOA when it's rental first. I would not say we would go to trial. The other alternative is that I'm going to give you the 2 months if that's what they owe, and they can show that they owe the 2 months, probably, or any fees as far as the court cost or any late fees. But if there's no lease, I probably will not go and give late fees. And let them know that the alternative would be that they could come back and file for HOA fees with a civil case or small claims.
I think the principal objective of an eviction action is possession. And so they can get the possession based on the non-payment of rent. Anything else is additional to that. So I don't think that there should be any reason to postpone the judgment based on the fact that they don't want the HOA fees. So I would grant it based on the non-payment of rent, include the rent in the judgment, and then tell them they can file small claims or whatever for the rest of it.
The other alternative is to set the eviction trial in 2 or 3 days. Tell him to bring the lease.
Okay. You proceed to trial, and during the landlord's opening statement, she says she does not understand what is happening because she's never done this before. The tenant also has never been in an eviction trial before. Do you explain how the trial proceeds? And then what if one of the parties still says they don't understand?
I think the easy answer is yes, you explain the process, the order of procedure and how and the burdens and that sort of thing. The problem comes, of course, when the person says, well, I still don't get it. And then the question becomes how many times are you going to repeat it and how far down are you going to break it down? You know, you try and rephrase it maybe one or two times in more maybe understandable language if you can do that. It may help to say, is there something particular you don't understand about the process? I don't think there's anything wrong with doing that as long as you're not, you know, giving them advice as to how to prove their case. But at some point, there's only so much you can do. I did a legal decision-making and parenting time trial yesterday where when it was the respondent's turn to testify, because they were unrepresented litigants, I basically start out with, okay, tell me about, do you have any response? And then when we get kind of the end of his testimony, he really hadn't indicated to me what he was seeking. What kind of legal decision-making, what kind of parenting time, anything like that. So I started with the broad question, what is it you're asking me to order today? And he started telling me about all the men that she slept with. And I'm like, okay, with respect to the child, though, as to who gets legal decision-making and who gets parenting time and when, what is it you're asking me to order today? Well, she didn't take the kid to the doctor when she should have, So at that point, I'm like, okay, I'm out. There's only so much I can do to try and draw out the information. And at some point, you have to, you've got that case management component where, I set this for 2 hours, we're at 2.5 now. It's just not a productive proceeding. So that's I think is the tougher decision about how much detail do you go into and how many times do you repeat it.
In a similar scenario where you have a plaintiff that may have legitimate cognitive impairment, say a traumatic brain injury, where you're going over the rules and they literally forget the rules as they're going, which has happened, what resources can you, in that scenario, what resources can you have the plaintiff avail themselves of? Are there court resources we can reach out to? Are there rescheduling things we can do where we can get additional resources in there to assist, or is that exceeding our authority?
Well, Judge Winthrop probably can respond as the chair of our Access to Justice Commission, but this is the sort of thing we're working on right now under Judge Carrillo's direction, one of the subcommittees with the forms and possible, we're working on, Judge McMurray is helping with a video that we're putting together on this issue. So I think we're in the process of trying to provide education for particularly self-represented tenants, but there are obviously situations like this with self-represented landlords who need the information just as well. So did I hear you volunteering maybe to help us with this?
Okay, we want to get to some of these others, but let's keep going. Okay, we're going to just switch to traffic arraignments. Okay. The self-represented litigant appears with a citation with the following charges: exhibition of speed, criminal charge; violation of license restriction, criminal charge; red light violation, expired registration and equipment, headlights, all civil. Defendant wants to plead guilty, responsible to everything, so she doesn't have to return to court. You know very well that your prosecutor, who's not there doing the pretrial conferences that day, will make a very reasonable plea offer to the defendant, including dismissing several of the civil charges and possibly reducing the criminals to civil. Should you let this defendant plead guilty today? Should you offer a pretrial conference? How strenuously? Do you advise of the consequences of the red light violation? Which, by the way, in case you don't know, is automatic traffic survival school by MVD.
Well, let me just make a pitch for the bench book. We have a number of you in the room and 90 around the state who review the scripts of every type of proceeding that you have. And if you follow that script, you're going to avoid some of this. For one, having the defendant admit everything on the record before you even have an opportunity to tell them they don't have to do that. They don't have to say anything and explain what the risk is and give them a warning about that. So, I know that every year you've all been through the training, and, people have some reluctance to follow the script, to be appearing as though they don't know what they're doing because they have to look down and read a script. But as I say so often, you're going to more likely give the impression that you don't know what you're doing if you're not following the script, and you get off base and you go, oh gosh, I should have warned you about that, and we're on the record, and anything you can say can be used against you. Well, you've already said, hey, I'm guilty of all of these. So just, at a minimum, follow the script.
Yeah, but now I want to double down on part of this question at least, okay? She's charged with criminal and also civil charges, but she tells you she wants to plead guilty because she does not want to have to come back to court again. Are you going to take that guilty plea? And this happens all the time.
No factual base.
I have found this to happen in my court, and I don't tell them what they should do. I simply say, it may be in your best interest to go see the county prosecutor and see if you can't come to a successful resolution of the issues that are before you. They can amend, modify, dismiss. I cannot. If you plead to me today, I am your worst nightmare. Are you sure you don't want to see the county prosecutor?
When we take a plea, one of the last things that we do is we get a basis in fact for the offense charged. So when they come in and they say, I'm just doing this so I don't have to come back, that is not a basis in fact. I reject their plea. I enter a plea of not guilty on their behalf and send them to the county attorney.
In response to Judge McMurray's question or comment, I think part of what he's getting at here is you have some issues with whether this is ex parte. First of all, it's clearly an ex parte proceeding because your prosecutor's not there. Can you conduct it? I think as long as the prosecutor knows you do your arraignments on whatever X day is for criminal cases, and they say, that's fine, Judge, we're not staffing it, they've waived their appearance and you can proceed. And I think you can take pleas, even on criminal charges under those circumstances, and I think you can impose sentencing, provided there are no victim issues. I think it's the prosecutor's obligation. If they know that that's what you're going to end up doing, if they choose not to appear, then they waive their presence. We used to have this come up a lot. And it's kind of frustrating because I think all of us would prefer to have the prosecutor there at all the proceedings just for this very type of scenario. But I think you ethically can do it as long as the prosecutor had noticed that you would be handling cases that way and not setting everything off regardless of how the person pleads. In terms of the scenario and some of the questions that are posed there, I don't think there's anything wrong with saying, you understand, it may be to your benefit to have this set for a pretrial conference. It's not uncommon for the prosecutor to make you some type of an offer where some of these may be dismissed in exchange for your plea to others. I wouldn't get any more specific than that. You need to be very careful. I would never say something like the prosecutor will always do this or this is what the prosecutor does, because for all you know, unbeknownst to you, this person has 84 prior convictions for, excessive speed, and the prosecutor is not going to offer a thing to this person. So I would just keep it sort of open-ended in general like that. And if they're insistent that they want to plead because they don't want to have to come back to court and they're just adamant about it, if I didn't have any reason why I thought it was improper or unethical for me to take the plea, I'd take the plea, and assuming they'd provide the factual basis for it. Our job here is to make sure people get justice, that they're treated fairly, that they're informed, and that in terms of self-represented litigants, making sure there's sort of an even playing field and that sort of thing. It doesn't go so far as to A, be their lawyer, or B, save them from their own poor decisions necessarily. So I think as long as you've kind of done those things, you're in good shape. Can you reject it and say, no, I'm just not going to take it? You can, but keep in mind you may not really be helping the person by doing that either. You know, if it's, I don't want to come back because if I miss work one more day, I lose my job and I can't feed my kids, they may be better off with you taking that plea that day.
What about a scenario where one of the charges is not on the bond schedule, so you have no idea what the typical penalty would be, and you have no input from the county attorney because they're not there?
Well, if it's a civil, presumably if you're talking about the bond schedule, it's a civil violation.
Well, even if it's a criminal, maybe one of the ones that's just uncommon, and there's no typical amount that the.
You are not tied to the bond schedule. You can impose any sentence that's a lawful sentence for civil traffic violations unless something specified different. It's $250 plus surcharges and fees for the different classes of misdemeanor. It's whatever the range of penalty is for that misdemeanor.
Okay, we have 15 minutes left. Let's move on to number 7.
No, let's move on to number 9. We have a lot of hearing officers here, okay? Right. We're going to run out. So number 9, the self-represented defendant makes it very clear in his opening statement that he was the driver of the vehicle, as he vehemently complains about the officer not being very nice. The officer forgets to identify the defendant as the driver during his case in chief. So the defendant made something clear in his opening statement, but now the officer has testified and has failed to identify the defendant as the driver. Should you ask the officer to identify the driver? Or do you just dismiss?
I may not be all that familiar with the way these proceedings go, but I'm guessing that before anything starts in this proceeding, both the various witnesses are sworn, and the fact that the self-represented defendant in his opening acknowledged he was the driver, to me, is probably sufficient to prove the evidentiary basis.
Please, I hope, because you're on the Court of Appeal, you may not know, but there is no prosecutor here. Okay, it's the officer who is a witness and sort of is the state, but is not really the state. It's kind of a strange hearing. It's a civil hearing.
Well, again, my initial take is that the defendant's made an admission that satisfies that element, and even if, well, I'll leave it at that.
You know, I think this is a good example. Thanks for putting that one in here, that, there are elements that are required to be proven, even in civil matters, and this is one of them. It's a fundamental element. So, it has seemed to me over the years that judges at the higher level courts, and I'm not referring to the Court of Appeals or Judge Winthrop, but at the Superior Court, for whatever reason, are less concerned about inquiring about and even helping to establish identity than I am as a limited jurisdiction court judge. And so this is what I have decided, and some of you have heard me say this before. Typically when you go in as a civil traffic hearing officer, you follow the script. It's sort of designed to assist the person who's been charged with the offense in understanding what the procedure is. But as Judge McMurray said, you have an officer there who's a witness. He's not an attorney. Now, maybe he or she has done it a jillion times, but nonetheless, they don't know me. And so I just tell them, look, I mean, this goes for everybody here. I'm gonna hold the state to its responsibility of establishing all of the elements, and I may even read what the citation is, and that way I feel better about not providing any kind of direction to, well, were you the person driving? Well, I didn't really hear the identification.
Judge Carrillo, would you ask the officer to identify the driver?
No, I wouldn't.
You just dismiss.
I dismiss.
Got it. Okay.
But the second part of that question was, what if you're not quite sure if the officer identified the driver because you've done so many of these today, your mind might have been wandering?
Judge Carrillo, would you ask the officer?
I don't do them enough.
Well, unfortunately, as you get older, this does happen. And, I'll just take a moment and I'll say, you know what, I need a second. And so, I'll go into the other room. Maybe there's somebody there that's with me in the court and say, you know what, I didn't hear this. Maybe I could listen back on the record for any comment that was made. That might take too long, but you do begin to question yourself. And I suppose you then are put in a position of having to ask if you don't remember. And that's on you and not on them.
And then, Mr. Reamer, do I have an obligation to report myself?
I've mentioned this before. There is no self-reporting requirement unless you feel real guilty and you want to throw yourself at the mercy of the commission.
All right.
But I did want to raise an issue that kind of a theme here is, the inconsistent, potential inconsistency of how you all deal with these things. So one person's good intention, discretion is another person's arbitrary action. And I think Paul's comment, and I believe there are lots of scripts. And the scripts, I think, are great, as are the development of best practices and the continued refinement of that. But then I think on the counter side, you kind of then question, well, are you all supposed to just be like judicial robots? No, I think you are elected and selected to exercise your best judicial discretion. So it's a tough topic to know, if I go to court X, I'm going to get the judge not asking the question. If I go to judge another court Y, the judge is going to help or perceived to be helping the officer, and I get a different result. And so I think the public is troubled by that.
One thing I do now, absolutely every time, no matter what the case is, I write it down, identification, location, all those, that acronym you use.
Just one question about this, and that would simply be, your thoughts on the argument, though, and that is, if in a civil traffic hearing, it's appropriate for the hearing officer or for the judge to do a certain amount of engagement with the self-represented defendant, which appears 99% of the time self-represented, to ask them, tell them what the options are. They don't say much. You can tell them it's your turn to testify, and you might have a couple of questions to ask them. If you're supposed to remain completely neutral in this process, though, is it not also appropriate to, at that same point, apply the same standard to the state, and that is to say to the officer, if you need to establish identity, and that was simply perhaps an oversight on their part, to ask, is that individual in court? And then it's up to them to then say, well, yes, as a matter of fact, the party is seated at the defense table, and so on and so forth.
Well, that's why I think it's important that regardless of which side you're asking the questions of, you're not making their case for them. Questions should really be aimed more at clarification rather than filling in essential fundamental elements. So, if the officer went, yeah, that guy over there was driving, and kind of nods his head, I think it's okay to say, now you said that guy over there, are you referring to the defendant? I don't see a problem with that. But I think if there's just nothing there, and you're just asking the question to establish essentially or find out whether there's a basis for an element or not, then I think you've stepped over the line.
Okay, so the officer has remembered to identify the driver, but the self-represented defendant says he had no insurance at the time, but the officer was too mean to him and didn't give him enough time to find it. He says he has his insurance today, but he doesn't want to show it to you because he doesn't think he doesn't believe he should have to.
And this actually happened.
This actually happened.
I think you just advise of the consequences, including a $1,000 fine and the suspension of his driver's license unless he shows it. Last one that we have time for, this is scenario number 7, a default judgment. The defendant is unquestionably personally served in a credit card case brought in the name of the original credit company. The plaintiff has filed for entry of a default judgment without a hearing and has attached supporting documentation and affidavits for a sum certain. Are you required to grant a default judgment without a hearing? Should you look for affirmative defenses, and are you required to do so?
Now, understand, panel, this has been very carefully crafted. We've stayed away from the controversy over portfolio and the debt buyers that have had a consent judgment entered against them. This is this is brought in the name of the original credit companies. We don't have that issue. And we have a default judgment applied for that's got supporting documentation. And it shows us a clear amount. Are you required to grant a default judgment?
Under the rule that's cited, it's discretionary with the judge.
Correct.
Should you look for affirmative defenses? Like statute of limitations?
I think what you're required to look for is whether the evidence presented supports the granting of judgment. In other words, is the information in the affidavit sufficient to do it? If you decide to proceed in that fashion, if the evidence does not support the granting of the judgment or the conditions that are contained in the judgment they give you to look at, then you don't have to.
If I might just make reference to scenario 13, which is another similar example, but related to a motion for summary judgment. And the answer there is absolutely not. You don't get a default motion for summary judgment just because the opposing party does not respond. The moving party still has to prove their case. And so I think that's just an extension of what Judge Winthrop is saying. But that's a very important point. There was a Court of Appeals case Judge Swan wrote, and we wrote that into the rules of civil procedure for our Justice Court proceedings.
Okay, what did we decide about asserting affirmative defenses? What do we know about affirmative defenses?
They have to be asserted.
Okay, by who?
By the defendant.
Or all well-pled allegations of the complaint are deemed admitted.
Yeah.
All right.
But you know, this is not so simple. I mean, there are, you have to be careful. I mean, how far you decide to get into this. I mean, I've talked with some of you for years about certain things, you know, whether or not in the contract, which is attached to the complaint, there's mandatory arbitration, you know, and here you are in court. Or, you know, you have the feeling that the sale of the vehicle wasn't reasonable. And, you know, but is that your job or not? These are hard questions. And I would encourage you to talk to each other, Charles and Judge McMurray and Judge Williams and others, about some of these issues that come up for you.
All right. I think it's time to wrap it up, isn't it, Charlie?
One more comment.
Well,
One more question.
I wanted to jump back to the previous scenario very briefly on the civil traffic. If you have a situation where the officers testified, they've essentially rested, but they haven't established all the elements, and it's about time for the defendant, would it be appropriate at that point to say, well, you haven't established, instead of letting the defendant start speaking and possibly establishing the elements that the state has failed to establish? Is that appropriate? Or what about in the criminal context? The state has presented a case, is rested, and a self-represented defendant is about to start their case. Is it appropriate at that point to say, whoa, you don't have to say anything, they haven't established beyond a reasonable doubt, dismissed?
Yeah.
Where should the judge, how should the judge?
Well, in criminal cases, the rule is right on point. It says that the other party can do it, or you can do it sua sponte. You can essentially direct a verdict of acquittal at that point. Well, you give the part of the state a chance to argue why you shouldn't, but it's pretty clear. I don't know that, I don't recall whether or not the civil traffic rules have a similar specific provision, but it is the state's burden to make that prima facie case, and if they haven't done that, I don't think there's anything at all wrong with just at that point, finding out not responsible, that they've not met their burden once the state's arrested.
Okay.
Just one last mention about rules. As you probably have heard, there are no longer rules of criminal procedure for criminal traffic. They've been abrogated. This is the first time that I remember in my lifetime as a lawyer that this book may get a little thinner.
Just a little. By a page and a half. That's about what it was, right?
Ladies and gentlemen of the panel, thank you very much. You have been helpful. I think it has illustrated the
Sorry, dropped the gun.
illustrates the trickiness of this area that we're getting into, and we're going to have to work on it ongoingly, but I think it's a valuable labor that we're undertaking, and you've helped us focus on it. So thank you very much.